We are just waiting for the chairperson, then we'll start. I think she's still not in the room.
Honorable Telezi,
Yes. Oh,
there's a message.
hello, Honorable Tireko, how are you?
Yes, there's a message in the WhatsApp group where the chair indicates that he will be arriving at 10:20 and requesting you to chair the sittings until he arrives.
Oh, I think maybe the confusion, I do understand, Honorable Tireko. I was talking about the chairperson of the commission. I'd already mentioned to them that the chairperson is on the way of the COCTA portfolio committee. But I saw
Okay,
that message. Thank you.
Okay, thank you.
We're going to close the door. No, let's leave it. Mamutlaluva, I had heard that there are some of your members who are still outstanding. I mean, but I suppose we can go ahead. How many are they? Maybe we can wait a bit. How many? Three.
But they're in the building.
Only building. Okay. Suggesting then we can start. We may start. Well, a very good morning to everyone. We will start, and as I explained earlier, when the chairperson of the commission was still outside the room, our chairperson, Dr. Mkhize, is on the way. His apologies, please. I must apologize on his behalf, but he will be here shortly. So my tender is very short-lived. I've been sitting here. He said I must apologize to you, Chair, and the members, but I must welcome all of you for coming to see the committee. And I must just say that as a COCTA committee, we like intimidating delegations because it means they take us seriously. So if there are so many of you, that's what we welcome. But really, it always is something we appreciate. Then I will welcome you, and I think, of course, you will introduce your team to all of us. And we are this portfolio committee sitting mainly this side. I think once we've done the housekeeping, we will start with the business of the day until the chairperson joins us. Maybe Sherin, I think you put up the agenda. I just wanted to find out here in terms of apologies and so that you can confirm the quorum.
Thank you very much. We do have apologies from Honorable Labaskachni that will be presiding over one of the mini plenaries today, so she won't be able to make the meeting. We also have an apology from Honorable Sompa that is on medical leave. Thank you, Chairperson. And then on the platform, we do have Honorable Tireko, we have Honorable Taibush. I see the Chairperson did sign in on the platform. So yes, and then we also have Honorable Steve Swart that's also on the platform. So Chairperson, we do form a quorum for this meeting. Thank you very much.
Thank you. Thank you, Sherin. I thought the chairperson, Mamtoko Mkonas Klaluva, that you'll introduce your team at the beginning of your presentation. Our team is all here. Maybe then very briefly as an introduction, in my understanding of the business of today, in summary, is really mainly, I'm not saying that it is the only thing, is mainly section 22, but also mainly, there can be two mainlys, is really the several input we have received from different religious leaders in terms of everyone is known, it's been in the public domain for the longest of time. So my understanding is that you have come to give us the briefing, but it's not just the briefing where we're going to say thank you, it was nice having you. It will then after that be, of course, engaging robustly about the issues that would have been tabled. Yes, Mr. Fanze.
Thank you, Honourable Chairperson. Good morning to everyone in the House. I would maybe just like to propose that we adopt the agenda. Thank you.
That's correct, yeah. Can I have a proposal?
That is my
Adoption.
proposal to adopt the agenda.
Thank you, Ms. Van Zyl has proposed, and Fagu, are you
Thank
second?
you very much, Chair. I second the proposal. Thank you.
Thank you very much, members. So I can welcome everyone and not, of course, greet and welcome the esteemed members, my colleagues in the COCTA committee. Welcome as well. So as I alluded to, Mam Klaluva, then we will definitely just listen to your presentation, and we allocated an hour to that. I think we think that that time is more than reasonable, and by which time, it seems you are surprised. We did allocated how many? 3. Well, the chairman had said is allocating 1 hour. We'll see. We'll see how it goes. But that's what he had briefed me was the time that was allocated to you. So it looks like you get a lot to say. Yeah. So if maybe at this juncture, I can hand over to you, member, so that you introduce the team. And then, of course, you then direct us as to who's presenting. Welcome once again.
The deputy chair will do the introductions, then I'll move on after him. Thank you.
Greetings, Honorable Chair, honorable members. It's a pleasure for us to be here. I'll quickly just take you through our team. My name is Prince George Mahlangu, and I'm the Deputy Chairperson of the CRL Rights Commission. Next to me is our Chairperson, Umam Togom Kwanazi Baluva. Next to her is our CEO, Dr. Mafadza. And then next to Dr. Mafadza, you have Advocate Spezulu Zulu, who is from our ICR unit. Next to Advocate, you have Commissioner Mapanga. Commissioner Mapanga is in our PEA unit or committee. Next to Commissioner Mapanga, you have Commissioner Professor Makopa, who is in our ICR Section 22 committee. Next to him, you have Dr. Raj Kavenda, who is in our research unit. Next to Commissioner Gavenda, you have Commissioner Sistona Makoboka, who is in our PEA unit. Next to Commissioner Makoboka, you have Commissioner Dr. Peto, who is in our research unit. Next to her, you have Commissioner Ngwe, who is in our PA unit. Next to Commissioner Ngwe, you have Commissioner Dr. Musala, who is in our research unit. Next to her, you have Commissioner Professor Abdurov, who is in our ICR unit. And next to him, you have Commissioner Ras Mantula, who is in our ICR unit. Advocate Ras Mantula, apologies, who's also chairing our ICR unit. Let me introduce the staff members at the back. Right to my right, you have Ntate Obed Simono, who is a manager in our PEA unit. Next to him, you have Ubabum Kolo, who is heading our communications team, also supported by Ubabun Rovu. Next to him, I saw right next to Babun, we have Cornelius. Yes, thank you, Cornelius Smarts, who is our CFO. and then Brian Makaketa, who is the senior manager in our research unit. Right at the corner there, strategically, so I think she can see everyone, is Valerie Naidu, who is the PA in the chairperson's office. I think, Chairperson, that's our team. That is all here. We have one commissioner who could not make it, and that's Commissioner Advocate Sidupane. But otherwise, all the commissioners are here, as well as the support staff and the CEO and CFO. Over to you, Chairperson.
Thank you, Prince Mahlangu. Clearly the offices are closed. CRL is locked up. We really love that as this committee. Maybe talking of introductions before I hand over to you, Honorable Chairperson. Just our team who are in the room. We have here Mr. Ndamase raising their hand. We have here there Umtolo, member of the Cooperative Committee. Gentlemen, welcome. I heard that is Mr. Bateman, and of course Marina Van Zyl. Other members are, of course, our own. You know, it's a hybrid. They are online. I think that will be it. Of course, everyone knows Sherin is our PA, who helps is our traffic cop. Thank you so much, Chair. Let me hand over to you. Then you'll direct us as to how you want to navigate this morning. Thank you.
Thanks a lot, Chairperson. I'm going to do the presentation, and then Advocate Zulu will do the legal issues. What we've done is that as part of the presentation, we also have a few clips, video clips, which we are going to play. They're very short, they're not very long. And then we'll have the legal framework. And that would be the end of our presentation after the legal framework. I'll start with unpacking our name, because I think our name defines who we are and what we're supposed to do. We're mainly about the protection and promotion, in this particular instance that we're discussing today, would say of religious communities, but we're responsible for cultural, religious, and linguistic communities. So it's a whole gamut of our responsibility. Our mandate is very broad. We're established in terms of Section 181, 1C of the Constitution of the Republic of South Africa, Act 108 of 1996, as an independent, impartial body accountable to the National Assembly. Our objects are listed in our Act as following: to promote respect for and further the protection of the rights of cultural, religious, and linguistic communities. When I move on, Honorable Chair, I'll be saying CRL to cut time. To promote and develop peace, friendship, humanity, tolerance, and national unity among and within CRL communities on the basis of equality, non-discrimination, and free association. And also to foster mutual respect among cultural, religious, and linguistic communities, to promote the right of communities to develop their historically diminished heritage, and to recommend the establishment or recognition of community councils in accordance with Section 36 and 37 of our Act. And then Section 5.1 looks at powers and functions. It starts with the Commission may do all that is necessary or expedient to achieve its objects referred to in Section 4, including to conduct information and education programs to promote public understanding of the object's role and activities of the Commission, to conduct programs to promote respect for and further the protection of the rights of CRL communities. And the Commission, we're also there to assist in the development of strategies that facilitate the full and active participation of CRL communities in nation building in South Africa, and also to promote awareness among the youth of South Africa of the diversity of CRL communities and their rights. We are also asked, more importantly, to monitor, investigate, and research any issue concerning the rights of CRL communities. We are also given the power to educate, more importantly, to lobby, advise, and report on any issue concerning the rights of CRL communities. And we're also supposed to facilitate the resolution of friction between and within CRL communities or between any such community and an organ of state where the CRL rights of a community are affected. We must also receive and deal with requests related to the rights of CRL communities. My machine is not jumping, thanks, CEO. We are importantly empowered to make recommendations to the appropriate organ of state regarding legislation that impacts or may impact on the rights of CRL communities. The issue of recommending legislation is very important. And then we're supposed to establish and maintain databases of CRL community organizations and institutions and experts on these communities. For instance, we need to know where in this particular instance, where each church is, who is running that church, etc., etc. Bring any relevant matter to the attention of the appropriate authority or organ of state, and where appropriate, make recommendations to such authority or organ of state in dealing with such a matter. Section 7, we have what we call our Section 7, which empowers us to conduct investigations in terms of Section 51E, where we can investigate any matter. We can do this ourselves, or we may designate one or more commissioners or other persons as an investigating committee to conduct the investigations on our behalf. Section 7 investigations, as part of that, way back in 2015, we embarked on an investigative study on commercialization of religion and the abuse of people's belief systems. That was in 2015. And this emanated from a complaint referred to us by the South African Human Rights Commission. As a part of this investigation, we made several recommendations. We thought we'd start there and then go up chronologically. Our recommendation was that religious communities should regulate themselves more diligently to be in line with the Constitution and the law. Communities should exercise their religious freedom with due regard to their legal, ethical, and community responsibilities. The Constitution leaves scope for all kinds of beliefs and opinions, even views which some may regard as extreme, are allowed and should not be regulated. I always give an example of I can worship a cat if that's what I want. The Constitution supports me in that. Views which lead to the abuse of human rights, for instance, hate speech, or to the violation of the law are a cause for concern. Existing legislation affecting the various aspects of religious organizations, which would cover training, education, employment, registration, immigration legislation, etc., needs to be enforced with due diligence, because the hearings, when we're doing this investigative study, showed that the existing legislation has many loopholes, and this creates opportunities for abuse. Although religious organizations exist as voluntary organizations, the Civil Rights Commission should provide essential assistance in helping organizations to get their house in order and to ensure compliance with existing legislation and, importantly, propose new legislation. The current disregard of fiduciary responsibilities in the religious sector by some in the religious sector is a serious concern. Religious organizations need to understand their responsibility in connecting religious freedom and recourse to ethical and community responsibility. There's a definite need to refer specific cases where organizations do not comply with the law to be referred to the relevant authorities, for instance, the NPA. Religious organizations are encouraged to get their house in order, among other things, by properly training and putting proper internal rules in place for their members. While there's an appreciation of bona fide foreign pastors serving the South African nation, the Department of Home Affairs should play a crucial role in curbing the abuse when considering visa applications. I'll give the example of the SIU recent investigations there and their findings. Each institution must have a finance committee chaired by a duly elected member of the institution. The treasurer must also be duly elected, while the religious leader should become an ex officio member if necessary. To solve the leadership succession challenges, each religious institution should elect its leadership as per the provisions of its own constitution. We've seen a lot of destabilization of churches around the succession plans. Religious institutions should elect their own oversight structures to manage the financial and internal affairs of their own institutions. When anomaly exists where religious leaders buy property, for instance, with the community's money and later own that property, proper investigations must be conducted first to establish this allegation. Where the fact is established, report must be tabled to the congregation and the religious leader must take corrective measure. The SIU covered some of the stuff in their report of 2026. Clear separation between business activity and religious activity should always be maintained. While the religious institutions are free to start businesses in their own business space, businesses should be registered in the normal course of registering businesses. We had found that there's a lot of selling and buying holy water, holy oil, etc., and that the church was not a registered business. And then we submitted this report to the Cooperative Portfolio Committee in 2017. The Cooperative Portfolio Committee then had their own, I won't say investigation, but like hearings, where they called the religious sector to come and make presentations. After our presentation, then they came up with their own presentation. Last year, we learned that this report had lapsed here in Parliament, but at that time, it was on the table. And the report said their recommendations. The committee notes that across the sector, there is agreement that there's abuse in the religious sector, and thus recommends the following. They said a national consultative conference, which should include the linguistic and cultural communities as well as the religious community, should be convened to give a platform to discuss challenges in the religious sector. So the CRL was asked to do this. Arising from the NCC, the following should be established. The Cooperative Portfolio Committee said there must be a charter for self-regulation. And they said there must be a code of conduct for the sector, which should be recognized by legislation. And then they wanted the ICASA mandate to be strengthened and other such bodies to penalize misleading media claims. For instance, when you say your holy water heals HIV and AIDS, and you've got that on television during the sermon, then we are more or less advertising a particular cure. So they said ICASA must be strengthened, and that legislation like the NPO Act and the Income Tax Act should also be strengthened to ensure registration of religious institutions. And the CRL, as per the decision of the Cooperative Portfolio Committee recommendations of 2018, early in 2019, very early around February, a national consultative conference was held in February 2019, as per the recommendations. Let me first explain what is the NCC. It's in our Act. It's a conference comprised of members of the Commission, delegates from CRL communities, delegates from every community council recognized in terms of Section 37 of the Act, delegates from the National House of Traditional Leaders. In the Act, it still appears like that, and it's now the National House of Traditional and Khoisan Leaders, the South African Human Rights Commission, PEN, South African Language Board, the Commission for Gender Equality, and the Youth Commission, that is now the National Youth Development Agency, delegates from the national government designated by the minister, delegates from provincial government designated by the premier, delegates designated by organized local government. We then held this NCC as per the 2018 resolutions using our Act. Section 25 of the CRL Act says the purpose of the NCC is to provide a forum for, one, the consideration of a report by the Commission on its activities, accomplishments, challenges, and any recommendations of the Commission. B, the evaluation of progress in South Africa with regard to the promotion of reform and furthering of the protection of rights of CRL communities and the furthering of peace, friendship, humanity, tolerance, and national unity among and within CRL communities on the basis of equality, non-discrimination, and free association. The formulation of requests and recommendations to the Commission concerning matters mentioned in paragraph B. We then look at those requests, the discussion of resolutions before the conference concerning requests to and priorities for the Commission. So our priorities are also determined through the NCC as per the Act, promoting appreciation for CRL diversity. And then when we held this NCC conference, these were the resolutions pertaining to religion that were tabled after deliberations. Under religion, the communities we serve recommended that the CRL Rights Commission must do the following. One, continue ensuring that there's a peer review mechanism in place by their own peers. Our working definition of a peer review mechanism is self-regulation and not state regulation, just like it is for many other professions in the country. And we're asked to continue with the advancement and promotion of a process to regulate religious practitioners and not the religion, but practitioners. Continue pursuing the implementation of the proposals that the Commission submitted to the nation and to Parliament in 2017. And then with these recommendations, the new body of commissioners who are here were appointed in January, 1st of January 2025. At our first strategic planning session, the CRL Rights Commission unanimously resolved to implement the NCC resolutions of 2019. The procedures of implementation, our access in section 20 of the Act states that the Commission may determine its own procedure with due regard to the principles of transparency. The procedure we followed in choosing and inviting organizations and churches to be part of the Section 22 committee was one, identifying the known umbrella organizations and mega churches to ensure a wider footprint. The aim was to make sure that if we get broad organizations to participate in the Section 22 committee, we'll automatically reach millions of congregants. Number two, we then wrote letters asking for meetings with the executive leadership of those organizations and mega churches. We identified this process as being the best process as per Section 20 of the CRL Act. During those meetings, we explained what is the CRL Rights Commission to those who might not know, what we intend to do, and why there's a need for a Section 22 committee. We then invited those organizations and mega churches to send their own chosen person to be their representative in the Section 22 committee. What does the Section 22 Section 22 of the CRL Rights Act say? It says the Commission may establish one or more committees consisting of members only, or members and staff or other persons to assist the Commission in the performance of its functions. Number 2, it says the Commission must determine the functions of a committee, must appoint a member of a committee as the chairperson of the committee, and may remove a member of a committee at any time, and may determine a committee's procedure. And then section 23 states that the Commission may delegate any of the Commission's powers to a committee of the Commission, B, assign the performance of any of the Commission's duties to any such member, staff member, or committee. And then we established this ad hoc committee for Christians. I'm going to zoom in on the Christian faith, although we have others for other faiths. This was launched on 2 October 2025 at the Rhema Bible Church in Randburg. It was during this launch that the inaugural representatives of the Section 22 committee at the time were introduced to the public. I'll go through the membership of the Section 22 Committee for Christians. One is the Council of African Independent Churches, who have about 8 million members. The source is Reverend Gift Morane, who is the president of this council. This council services what we would say Mtwana Amazayoni, who are normally worshipping next to the rivers or in the field, etc. They've got millions of people. Number 2 is the Nazareth Baptist Church, which would be known as Ushembe. They are also part of the Section 22 committee. They have about 6.7 million membership. The source of that number is Mr. Ngwane, Mr. Lizungwane, who's the Secretary General of Ebuhleni Nazareth Baptist Church, which is the biggest formation of the Nazareth Baptist Church, Washembe. Mr. Lizungwane represents Ebuhleni Nazareth Baptist Church under the leadership of Inkosi Munyazwe Zulu. Then there's Inkosi Pagama, who heads Gauteng Nazareth Baptist Church, is also a member. Then there's Reverend Joseph Mhlongo from Ginyezinye Nazareth Baptist Church, and then Reverend Solomuzi Matenjwa from Tembezinhle Nazareth Baptist Church. And then there's the Moral Regeneration Movement. We thought it was very critical that we include the Moral Regeneration Movement headed by Father Mkachwa, because that is the vehicle by which we said as a nation we want to be looking at issues of morals and ethics. So they're part of the committee. Then there's the Rhema Bible Church. Pastor Joshua Macaulay, who's a senior pastor there. We included the Rhema Bible Church because we had been working with them from the very beginning with Pastor Ray Macaulay, who has been guiding the Sarah Rights Commission in ensuring that whatever we recommend does not violate the rights, especially of charismatic churches. And then we have the Zion Christian Church, popularly known as the ZCC, with approximately 11 million people. The source is Google. They say between 11 million and 16 million. We took the lesser number. Professor Themba Musia is a senior member of the church, represents the church. His Grace appointed him, His Grace, Bishop Barnabas Lefanyane. And then we have the St. Agnes Zion Christian Church. They are also included in the 11 million above, represented by Reverend Pete Lefanyane, who is a member of the Executive Committee of the St. Agnes ZCC. Then we have the South African Council of Churches, which represents 16 million members of the mainline churches, represented by Reverend Oscar Madlala, who's a member of the National Executive Committee. Then we have the Evangelical Alliance of South Africa with 2.5 million members, represented by Dr. John Maloma, who's the vice chairperson of TISA. During the launch, something we knew going into the launch that there was something unique about the group of people that the churches had given to us. They were mainly men. The issue of gender balance is an issue that is being discussed everywhere in the country, but the issue of gender balance in the religious sector is a challenge that needs to be looked at. So the committee we had was consisting mainly of men, 100%, not by our own design, but by the fact that the churches wanted to bring in their most senior people. And their most senior people happened to be men. We then said at the launch, which is something we had discussed, that women from the Christian sector will be co-opted. We identified a few women that we had been working with as the Sarah Commission for some time, Reverend Dr. Kolisile Mhlongo Jones, and Reverend Mamura Hololo, and Reverend Nosipo Daniels, who passed away last month, was part of the Western Cape religious leadership. And I was also asked to deal with the issue of Professor Musa Kulu's resignation. I was approached by members of the Section 22 ad hoc committees complaining about Professor Kulu's behavior in meetings. I then informed Professor Kulu about the complaints, and the members, who are very senior people, as you can see, I was then invited to come and observe at the next meeting what had been happening. Their main issue was that Professor Kulu has a paper he has called a white paper. I'm sure members will recall that I think late last year or early this year, there was an issue of there's a white paper. And I had said, it must be fake news. We don't know anything about the white paper. This was the first time I found out that there's a white paper. And the members were saying they want to establish their own paper. So they asked me to come in and observe at the next meeting. This was the first meeting I attended. I'm sure you know that Professor Kulu said I was attending all meetings and chairing all meetings. If I had been doing that, there would have been no need for members to complain to me. So it's a true fallacy to say I was attending. We then received a letter from members of the Section 22 committee of a vote of no confidence in Professor Kulu. Their relationship had totally broken down. I informed Professor Kulu of this, and in response, he resigned. But the actual nitty-gritty details of what they were fighting about can be better articulated by the members of the Section 22 committee. I can only attest to the part where I was present, which is that meeting that asked me to attend. We then have what we call a subcommittee dealing with GBVF, in sacred spaces. We zoomed in on sacred spaces to deal with GBVF in the religious sector, but also in the cultural sector. There's a lot of abuse that happens that is linked to the two sectors, whether it's traditional healing and the religious sector. The objectives of the subcommittee, which consists of commissioners from the SARL Commission, we decided that we'll bring in expertise of people within the SARL committee who deal with GBVF in sacred spaces, because the issue of GBVF in sacred spaces is not the same as GBVF. I'll give a crude example. If one young woman is raped by Tammy and runs away and she goes to open a case. In these cases, I'm sure some of you have realized that the abuse goes on for many years. We saw this. One of the most famous cases would be the Omotoso case, for instance, where the abuse had been going on for many years, which is not normal in other mainstream rape cases. And we also have the issue of God said, you must sleep with me. And in traditional healing, they would say, your ancestors are saying, you must sleep with me. And we'll be looking at engaging victims and activists and survivors on how legislation and government programs can be sharpened to facilitate prevention of GBVF in sacred spaces and effective prosecution of perpetrators in this area. We are going to be identifying survivors of GBVF, working with activists in the area, and will facilitate engagement with survivors in order to gather evidence, perspectives, and practical proposals to strengthen public understanding that no cultural or religious justification may override constitutional rights. We are also to analyze barriers to reporting, support seeking, and access to justice, including language barriers and stigma. And we'll look at abuse of authority by religious leaders, some, manipulation through spiritual dependency, suppression of reporting to protect reputations of the religious leader, sometimes the church itself, pressure on survivors to forgive without accountability, and inadequate safeguarding mechanisms within the institutions of faith and traditional healing. The GBVF subcommittee was launched on 5 February 2026. There was a reaction to this launch. The survivors at the launch encouraged other victims to come forward and share their experiences of GBVF in sacred spaces. One of those survivors was Cheryl Zondi, who was part of the Omotoso case and was the first to give evidence in public under the scrutiny of the media. However, on 16 February 2026, a clip was released attacking those survivors who were at the launch, were asking other survivors and victims to come forward. And because of that clip, that created a lot of harm in the sector, and especially with victims, and survivors. I'll play this clip to you. As a result, the victims and survivors were discouraged from coming forward. We'll show you just a brief series of video clips. Most of them are from what we call the South African church defenders, recorded by them, placed on their Facebook page. And I'm sure, honorable members, honorable chairperson, you can make your own conclusions about this particular situation. They're trying to get to the videos, or it's downloading. The first video will look at intimidation of victims of GBVF in sacred spaces. Particularly, this was attacking one particular witness who has gone through massive trauma. She had been abused by Omotoso since she was 14 years old. So she's had a very difficult time. And as a nation, we're supposed to be supporting such people instead of threatening them. You'll see the clip when it plays that there's a definite threat, that for other young people, it would scare them to come forward. And the timing of it, that on the 5th, we'll hold this, and then on the 16th, they release this video. The other video will show you, talks to what has been circulating, saying that the chairperson of the Sarah Rights Commission says, if you hear from God, you must be mad and you must be taken to the mental hospital. We'll give you the whole video and what was the context there and what kind of the religious leaders were referring to. And the third video deals with the clip that the church defenders also has in their Facebook page, where they say, I said on national television that people must take off their underwear and wave it to heaven, and the angels will wave back their underwear. A person who can say all those things does not deserve to be in a Chapter 9 institution, I agree. If you can say such things, because that is a terrible thing to say. So you'll see that video as well, and you'll see that they say it's me who said those things, whereas it's Prophet Mboro who said that. But in their Facebook page and in their posters and everywhere they go, they say, I said those things. Yes, you can play it, thanks. This is the clip from IOL reporting on the launch, where the survivors were asking others to come forward and report. Cheryl Zodi, she described this as very, that people must come forward. They then started, we don't have sound. I'm sorry about this. Technology does this all the time.
Why don't we let you proceed? You will come back to this.
Yes. We'll come back to the clips. Yes, Honorable Chair. What the clips show you is what kind of an organization is this called Church Defenders, and how far are they willing to go? The first clip refers to a threat to Cheryl Zondi saying that we have a sex tape, your sex tape, which was interdicted in the High Court, which we're going to play and show it to the whole nation. This happened in spite of the fact that there's an interdict on that sex tape, but they continued to threaten her with that sex tape. Hopefully, we'll catch up with the videos when we get to them. And the second video is an interview in court during the Omotoso trial, which contextualizes whom I was referring to when I said those people need to be admitted, those types of people who say, God said you must eat grass, God said you must sleep with me, God said you must take your money and give it to me, etc., etc. The last one, oh, okay. This is the second one, but it still doesn't seem to have the sound.
I don't think you should keep referring back to them.
Yes,
They're
I
just trying
think
to
so.
fix this.
To save
So
time,
just
we
proceed
will
and then we'll identify
back.
the time. They still have a problem.
Yeah, thank you, Honorable Chair. And then I'll hand over to Advocate Zulu to deal with the legal issues.
Thank you, Honorable Chair. This segment of the presentation is geared towards a safer, ethical, and accountable religious sector, balancing freedom with responsibility. In the interest of time, I will give an abridged version of my presentation. Honorable Chairperson, honorable members, and distinguished guests, we begin with the constitutional foundation of this discussion. Section 15 of the Constitution of the Republic of South Africa guarantees every person the right to freedom of conscience, religion, thought, belief, and opinion. This right is one of the cornerstones of our constitutional democracy. It protects not only individual belief, but also collective.
Sorry, can I just so Chairperson, just explain this presentation? What is the presentation? Just explain what it is.
This presentation covers the legal framework that the CRL is using in all our proposals for, number one, vetting, for instance, which is in the Children's Act, that anyone who's going to work with children must be vetted, including religious leaders, including people in customary initiation, including everyone will have access to children. It also establishes the issue of freedom of religion within the framework of the Constitution, and what freedom of religion in the constitutional sense with all the other rights in the Bill of Rights that
Okay,
exercise your freedom of religion. But
yeah, so you are basically giving a presentation of how you approach.
yes.
All right, that's what's
Thank you,
missing.
Honorable Chair.
Honorable Chair, may I please request that the slides, we continue from the slides? PowerPoint presentation. This right, the freedom of religion, is one of the cornerstones of our constitutional democracy. It protects not only individual belief, but also collective worship and the institutional autonomy of religious communities. South Africa is proudly diverse, home to Christianity, Islam, Hinduism, Judaism, African traditional religion, and many other faiths. However, as with every constitutional right, freedom of religion exists within the broader framework of the Bill of Rights. No constitutional right is absolute. Religious freedom cannot be exercised in a manner that infringes upon the dignity, equality, safety, or bodily integrity of others. The CRL Rights Commission wishes to emphasize this critical principle. Accountability does not undermine religious freedom. Rather, accountability strengthens and protects the integrity of religion itself. Our position is not about interfering with belief or theology. It is about ensuring that individuals operating within positions of spiritual authority do not abuse vulnerable members of society under the guise of religion. The Constitution protects belief. It also protects people from harm. Honorable members, it is important to distinguish between ethics and legality because the two are not always the same. Ethics concerns what is morally right or wrong. A religious leader may manipulate congregants emotionally or financially in deeply unethical ways, even where criminal prosecution may not immediately follow. We have seen disturbing incidents where congregants were instructed to consume harmful substances like petrol, grass, and snakes, or engage in degrading acts in the name of faith, such as waving underwear in the air. Even where prosecution proves difficult, such conduct violates the ethical duty owed by spiritual leaders to those who trust them. Legality, on the other hand, concerns conduct prohibited by law. When religious leaders engage in rape, fraud, trafficking, money laundering, or even child abuse, the matter moves beyond ethical failure and into criminal conduct. The Commission's concern is that ethical failures often become the breeding ground for criminal violations. If there are no internal accountability systems within religious institutions, harmful conduct escalates unchecked until tragedy occurs. Ethics must therefore operate as the first line of accountability, while the law becomes the enforcement mechanism when ethical safeguards fail. Regulation is often misunderstood as oppression or interference. In reality, regulation exists in every sector where public trust and vulnerability are present. Regulation establishes standards, accountability mechanisms, and systems to prevent abuse of power. The purpose is public protection. Religious leaders hold immense influence over people's emotional, psychological, financial, and spiritual well-being. Congregants place extraordinary trust in them. That trust must not become an opportunity for exploitation. Regulation also strengthens legitimacy. Authentic institutions benefit when fraudulent individuals are identified and removed from positions of authority in religious institutions. Importantly, prevention is always better than prosecution. Once harm has occurred, once a child has been abused, and once funds have been misappropriated, once lives have been destroyed, the damage cannot simply be reversed by criminal proceedings. Regulation protects the dignity of congregants and preserves the integrity of genuine religious practice. Every profession that exercises authority over the public is regulated. Lawyers are regulated by the LPC, doctors are regulated by the HPCSA, nurses are regulated by the SANC, and engineers are regulated by the ECSA. These professions are not regulated to destroy them. They are regulated because society recognizes the potential harm that may arise when power is exercised without oversight. A lawyer who defrauds a client may face criminal prosecution and professional deregistration. A doctor who abuses a patient faces criminal and professional consequences. An engineer whose negligence causes harm may lose professional standing. The question before us is therefore very straightforward. If society recognizes the need to regulate professions that exercise influence over people's lives, why should religious practitioners, who often hold even deeper influence over the vulnerable, exist entirely without accountability structures? This commission submits that accountability and freedom can coexist. A major misconception must be addressed clearly. The CRL Rights Commission is not advocating for state control over religion. We are not proposing that government officials decide doctrine, determine who may preach, or interfere in theology. That would violate the Constitution. What the Commission advocates is self-regulation by the religious sector itself. This means that religious communities establish their own codes of conduct, accountability structures, vetting procedures, and disciplinary systems, and that are going to be independent of government interference in doctrine. This distinction is very critical. This will mean that theology will remain free, belief will remain free, worship will remain free, but conduct must be accountable. The Commission's role is facilitative. It is to encourage the sector to develop sustainable systems that protect congregants while preserving constitutional freedoms. We must distinguish between regulating religion and regulating practitioners. Regulating religion would involve controlling beliefs, sermons, doctrine, scriptures, or forms of worship. That is constitutionally impermissible. Regulating practitioners, however, concerns conduct. It concerns minimum standards, background vetting, qualifications, codes of conduct, and complaint mechanisms. This distinction already exists in other professions. Regulating a doctor is not regulating medicine, and regulating a lawyer does not regulate the law. Similarly, regulating the conduct of a religious practitioner does not regulate religion. The sacred space of belief will remain untouched. What becomes accountable is the individual who occupies a position of public trust within that space. Honorable Chairperson, this slide highlights one of the most urgent concerns before the Commission: the protection of vulnerable persons, especially children. The Children's Act already recognizes the necessity of vetting individuals who work with children, such as teachers, social workers, and caregivers. They all undergo screening because society understands the risk involved. Yet, across religious sectors, many individuals continue to work very closely with children without any formal vetting mechanisms. Sunday school teachers, madrasa instructors, initiation school leaders, youth camp organizers, and children's choir leaders. These individuals often have direct and unsupervised access to minors. The Commission is not singling out any faith tradition. This is a cross-sector vulnerability affecting all religious communities. The question is simple: why should children receive less protection in religious spaces than they receive in schools or other institutions? Protecting children cannot be optional. The examples reflected on this slide are not hypothetical. These are documented cases that have appeared before South African courts and law enforcement authorities. These are cases involving rape, human trafficking, financial fraud, sexual abuse, death during initiation practices, and domestic violence concealed within religious communities. The Commission recognizes that the overwhelming majority of religious institutions operate lawfully and ethically. However, even a small number of abusive leaders can cause devastating harm because of the immense trust placed in them by congregants. These incidents demonstrate why reactive criminal prosecution alone is insufficient. By the time law enforcement intervenes, the damage has already occurred. The absence of internal accountability mechanisms creates environments where abuse may continue unchecked for years. The Commission therefore submits that ethical oversight and preventative accountability structures are essential to protecting congregants and preserving public trust. The SIU report, released under the Proclamation 154 of 2024, reveals a deeply concerning pattern of exploitation within South Africa's immigration system involving individuals presenting themselves as pastors and prophets. The SIU found that foreign nationals obtained visas and permanent residence through fraudulent marriages, forged life partnerships, falsified financial documents, and coordinated syndicate activity. In several instances, the same fraudulent documents were circulated among religious networks to support immigration applications. The report further identified suspicious financial activity within church-linked structures, including large flows of money disguised as tithes or seed offerings, as well as the use of church-registered entities in questionable financial transactions. Importantly, the SIU also exposed failures within the Department of Home Affairs itself, including corruption, collusion, and officials approving permits without proper verification. In one case, an adjudicator approving an application was reportedly a member of the applicant's own church. While the SIU has made several criminal, administrative, and disciplinary referrals, the key concern for the CRL Rights Commission is this. These individuals were already functioning as spiritual leaders long before law enforcement intervened. They had access to congregations, children, finances, and positions of trust without any meaningful vetting or accountability mechanisms within the sector itself. This report strengthens the CRL Rights Commission's position that self-regulation within the religious sector is necessary, not to regulate belief or doctrine, but to regulate conduct and protect the public. The Commission is not advocating for state control of religion. Rather, we advocate for peer-led accountability mechanisms that can verify identity, immigration status, and ethical fitness before individuals assume positions of spiritual authority. The SIU findings demonstrate that where there is high public trust but no verification, religious institutions become vulnerable to exploitation by organized criminal networks. Ultimately, the greatest victims are ordinary congregants, communities who place their faith and trust and financial support in these leaders. The findings referenced in this slide demonstrate systemic vulnerabilities identified through investigation. To reiterate, the Commission's concern is not with religion itself, but with the reality that high trust environments combined with low verification create opportunities for criminal exploitation. There is currently a significant regulatory gap even at municipal level. Many religious institutions operate from office parks, warehouses, industrial buildings, and other premises not designed for mass gatherings. This raises serious public safety concerns: fire hazards, overcrowding, inadequate sanitation, insufficient emergency exits, traffic and noise disruptions affecting nearby communities. Municipalities currently rely mainly on zoning and general noise bylaws, which are insufficient to address the realities of modern religious gatherings. The Commission therefore recommends the development of a model municipal bylaw in collaboration with COCTA, SALGA, municipalities, and other relevant stakeholders. These bylaws should address occupancy limits, fire safety compliance, sanitation standards, zoning approvals, and public safety measures. This is not about restricting worship. It is about ensuring that when members of the public gather in large numbers, they do so in environments that are safe and compliant. The Commission currently has 3 active court proceedings instituted against it, challenging aspects of its work, including proceedings in the Pretoria High Court, the Johannesburg High Court, and the Constitutional Court. The Commission will defend its mandate in every court as required. Litigation is a democratic right, and the institution of legal proceedings itself does not establish that the Commission has acted unlawfully. What the Commission must address directly is the risk of public misunderstanding that this litigation may generate. Religion is among the most sensitive matters in our society. When court proceedings frame practitioner accountability as an attack on religion itself, it creates confusion, inflames tensions, and undermines the very constitutional objective of the Commission. The Commission therefore wishes to affirm 3 positions directly. Firstly, due process was followed. The Section 22 committees were established within the Commission's statutory mandate under the CRL Rights Commission Act 19 of 2002. The Commission's mandate explicitly includes promoting and protecting the rights of religious communities. These committees are the very mechanism by which that mandate is given practical effect. The procedural requirements under the Promotion of Administrative Justice Act were observed, and the Commission acted within its constitutional, and legislative authority at every stage of the process. Secondly, no one is attempting to regulate religion, doctrine, or internal governance of religious institutions. Doctrine, theology, liturgy, and the internal structures of religious communities remain entirely outside of the scope of this initiative. These sacred spaces are untouched. What is subject to accountability is the conduct of the individual practitioner, the human being who occupies the pulpit, the position of trust within that space. Belief is free, harmful conduct is not. These are not the same thing, and those who conflate the two do a disservice to the public and to the faithful. Thirdly, religious institutions should welcome this initiative because it protects them. Self-regulation is the most powerful instrument that authentic religious communities possess to distinguish themselves from fraudsters and imposters, and those who seek to exploit the sacred space for personal gain. Accountability frameworks will weed out the fakes. They protect the integrity and credibility and the public standing of every legitimate faith community. Consider the professions we have referenced throughout this presentation. Lawyers, doctors, engineers, and nurses. They are not regulated. They are not diminished by their professional oversight. They are trusted precisely because of it. The public has confidence in these professions because they are mechanisms available to remove those who abuse their positions. Religious communities deserve the same public confidence, and accountability is how that confidence is earned and maintained. Every crime committed under the guise of religion damages the reputation of all genuine believers. Every scandal that goes unaddressed because there are no internal accountability mechanisms is a wound inflicted not only on the victims, but on the faith community itself. Embracing accountability does not weaken religion, it protects it. The Commission's position is therefore very clear. Litigation that misrepresents practitioner accountability as an attack on religion does a profound disservice to all South Africans of faith. True religious freedom is not threatened by the removal of those who abuse it. It is strengthened by it. The mandate of the CRL Rights Commission is protection and not persecution. We affirm unequivocally that religious freedom must remain protected. Doctrine and theology must remain free from state interference. Belief itself must never be regulated. But where individuals hold positions of extraordinary trust and influence over vulnerable people, accountability becomes necessary. The Commission believes that self-regulation offers the most constitutionally appropriate path forward, one that preserves religious freedom while protecting congregants from harm. Our objective is not to weaken religion, it is to strengthen public trust in religious institutions by ensuring integrity, accountability, and protection for all who enter these sacred spaces. Honorable Chairperson and honorable members, I will now move to the second part of my presentation, which will address the responses to sector submissions and concerns. Part 1 of this presentation focused on principle. We addressed the constitutional framework governing freedom of religion, the distinction between regulating belief and regulating conduct, the importance of accountability, and the urgent vulnerabilities that exist within the religious sector. The Commission has demonstrated that accountability is not the enemy of religious freedom. On the contrary, accountability protects the integrity, legitimacy, and credibility of religion itself. This section responds directly to the concerns, objections, and submissions that have been raised before this portfolio committee by various stakeholders within the religious sector. The Commission welcomes these engagements because constitutional democracy depends on robust public participation and open debate. However, it is equally important that public discourse be grounded in facts, constitutional principles, and accurate representations of the Commission's work. Unfortunately, much of the public narrative surrounding this process has been characterized by misinformation, misrepresentation, and in some instances, deliberate distortion of the Commission's position. The Commission therefore considers it necessary to place the factual and constitutional position clearly on record before this committee. Honorable Chairperson, the central question throughout this discussion remains unchanged. How does South Africa preserve the sacred constitutional right to freedom of religion while ensuring that vulnerable people are protected from abuse committed under the cover of religious authority? It is to that question that the Commission now turns. A common objection to accountability frameworks is that religious leadership is a divine calling, not a profession, and therefore cannot be governed. The Commission respectfully disagrees. A calling is spiritual and personal. The CRL Rights Commission does not regulate belief, doctrine, worship, prophecy, or faith itself. What the Commission seeks to address is conduct. Once a person exercises authority over congregants, receives public funds, counsels vulnerable people, works with children, or even occupies a position of trust, accountability becomes unavoidable. The constitutional principle is simple. Belief is protected, conduct is accountable. This principle already exists across society. Traditional healers, doctors, and lawyers may all describe their work as a calling, yet all remain subject to accountability because influence over vulnerable people carries responsibility. The Commission therefore submits that spiritual calling and accountability are not incompatible. They exist in different constitutional spaces. There has never been any proposal to regulate religion itself or people's callings. The concern has always been the conduct of individuals claiming to have had the calling, exercising extraordinary public trust and power. The Commission must now address the claim that peer review processes lack legitimacy or are based on the so-called lapsed mandate. That claim is incorrect. The constitutional mandate of the CRL Rights Commission originates from Section 185 of the Constitution. It is permanent, it does not expire, it does not depend on periodic political renewal. Furthermore, the recommendation for peer review and self-regulation do not originate solely from the Commission. It emerged through engagements involving this portfolio committee itself. The Commission initially proposed that the religious sector develop internal accountability structures. This portfolio committee subsequently strengthened that position through recommendations supporting self-regulation, accompanied by a code of conduct framework. This recommendation can be found in this committee's 2018 report. Importantly, the religious sector has had opportunities over several years to participate meaningfully in these discussions. What concerns the CRL Rights Commission is that some public narratives now portray long-standing discussions as though they suddenly emerged without consultation or constitutional basis. That is not supported by the record. The Commission must also place on record its concern regarding the deliberate circulation of misleading and selectively edited material intended to create fear within the religious communities. Public disagreement is legitimate in a democracy. Disinformation, however, is not. Accountability does not alter the constitutional relationship between religion and the state. It actually strengthens public trust in that relationship. Much has been said publicly about the Section 22 committees, including claims that it is unlawful or unconstitutional. The legal position is clear. No court has interdicted the committees or the CRL Rights Commission from continuing its work. Until a court rules otherwise, the Commission remains constitutionally obligated to fulfill its mandate. The Commission fully respects the judiciary and awaits the outcome of all legal processes. Equally, Parliament must respect the separation of powers by allowing the courts to determine the matter properly before them. Another misconception that must also be addressed is that the Commission has never prescribed a single model of accountability, nor have we proposed one central religious council. Peer review means the sector itself develops appropriate standards, structures, and disciplinary processes. The Commission facilitates the dialogue. It does not impose doctrine or institutional design. The concern, however, is that voluntary ethical charters without enforcement mechanisms have repeatedly failed to prevent harm. Where there are no consequences for misconduct, accountability becomes symbolic rather than protective. The Commission therefore submits that ethical standards without enforceability are insufficient. South Africa faces a national crisis of gender-based violence and femicide. The President himself has declared GBVF as a national disaster. The religious sector is not immune to this crisis. The Commission's concern is that maintaining environments with weak accountability structures creates conditions in which abuse can remain hidden, unreported, and normalized. The overwhelming majority of religious leaders serve ethically and faithfully, but where systems lack accountability, abusive individuals are able to exploit positions of spiritual authority for years before intervention. Opposing accountability mechanisms may not be intended to protect abusers. But the practical effect of removing oversight is that abusive individuals benefit from the absence of scrutiny. The Commission therefore argues that prevention is not optional, it is necessary. The Commission also distinguishes carefully between unconventional religious expression and harmful conduct. Religious freedom protects theology. It does not protect conduct that places lives, dignity, or health at risk. Encouraging congregants to abandon essential medication, consume dangerous substances, or submit to degrading treatment moves beyond protected belief and into harmful conduct. The constitutional rights to dignity, bodily integrity, and safety remain fully applicable within religious spaces. The Traditional Health Practitioners Act presents as an important parallel that cannot easily be ignored. Traditional healers operate within deeply spiritual and cultural systems. They are protected under the same constitutional provisions frequently invoked in opposition to governance frameworks for religious practitioners. Traditional healers also speak of a calling. They work with vulnerable people, they handle finances, they occupy positions of trust, and yet Parliament has enacted the Traditional Health Practitioners Act and established a regulatory council. That legislation remains constitutional. The Commission therefore asks a direct constitutional question. What legal distinction exists between traditional leaders and religious practitioners that would make accountability constitutional for one, but unconstitutional for the other? If both are protected under Section 15 and 31, and both exercise influence over vulnerable people, then the constitutional argument against accountability becomes extremely difficult to sustain. The Commission submits respectfully that accountability frameworks and constitutional religious freedoms are not mutually exclusive. South African law already demonstrates this in principle. The Commission must also respond to the argument that existing laws are already sufficient and that no additional framework is necessary. The Commission disagrees. Existing criminal law is largely reactive. It intervenes after harm has already occurred. But constitutional governance must also concern prevention. The question is not only whether perpetrators can eventually be prosecuted. The question is whether systems exist to reduce the likelihood of harm occurring in the first place. Repeated incidents involving fraud, abuse, dangerous practices, and exploitation demonstrate that gaps remain. The Commission further notes that public calls for accountability have not only come from institutions, they have come from ordinary congregants, victims, survivors, families, and communities affected directly by abuse within religious environments. Democracy requires parliaments to hear all those voices as well. The Commission therefore submits that voluntary codes of conduct without enforceability mechanisms cannot adequately protect the public. Accountability mechanisms exist not to burden legitimate institutions, but to protect the integrity of legitimate institutions from those who exploit religion for personal gain. Honorable Chairperson and honorable members, the Commission concludes its part 2 by reaffirming 6 guiding principles. Firstly, that doctrine, belief, and worship remain constitutionally protected and beyond state interference. Secondly, the religious sector itself must lead the development of accountability mechanisms. Self-regulation remains the Commission's preferred approach. Thirdly, Existing religious charters and ethical codes of conduct should form the foundation of future frameworks, but ethics must be supported by real accountability if congregants are to be protected. Fourth, the Commission respects ongoing court processes and remains fully bound by the rule of law. Fifth, Parliament must continue to safeguard the independence of Chapter 9 institutions established under the Constitution. And finally, public protection is non-negotiable. Every congregant, every child, initiate, and vulnerable person seeking spiritual guidance deserves safety, dignity, and protection from exploitation. Thank you, Honorable Chairperson.
Thank you very much, Chairperson. That concludes our presentation to the Honorable Portfolio Committee. Thank you, Chairperson. Over to you.
There's one thing. Honorable Chairperson, there's something I would like to correct from the slides. Omotoso was charged with the rape, human trafficking, and racketeering, but we all know he was not found guilty for certain reasons that had nothing to do with the witnesses. Thanks a lot, Honorable Chairperson.
So what are you correcting then?
Yes.
What were you correcting?
Oh, it's correcting. It appears in the slides as Omotoso was found guilty. I was saying he was charged and he was found not guilty.
No, that's clear.
Okay, thanks, Honorable Chair.
Okay, thank you. Thank you very much. Well, my colleague, Honorable Nkosi, welcomed you in my absence. I was on the hybrid, so I must also just extend the same word of welcome to the team. Honorable Nkosi said you were an intimidating delegation. I also do want to confirm that we feel very overwhelmed and intimidated. I was also informed that you objected to the 1 hour and you allocated yourself 3 hours. But I think you've been very considerate to us by reducing it to almost 2 hours. So at this point, well, maybe 1.5 hours. At this point, I think we must say thank you for your presentation. We would like to engage on quite a number of issues, but I wanted to check if members, we could just start by clarifying what might not be clear in terms of the information tabled before we can engage on the issues. Members, any specific clarification, or you would like to just go on to the conversation? I'm assuming the other members who are on the virtual platform can follow. Can you try and align so we can see who is where? Be tricky managing these gadgets. All right, thank you. Let's start with Honorable Ndamase. We will follow. Thank you.
Thank you very much, Chair. Greetings to the meeting at large. Just one clarity, Chair, from me. I have heard the Chairperson articulating the issue that has to do with Professor Ulu's resignation. But of course, we have also received a correspondence from Professor Ulu about him being subjected to state security agencies. Can there be clarity in relation to that? Thanks, Chair.
Maybe, why don't we just clear issues around Professor Kulu? Maybe not clear, but just clarify. The Chairperson has indicated that there were complaints We've not really seen those complaints. Are they open for sharing? And also then you can deal with this issue. Have you been aware of this other affidavit, and is there an issue around the state? Maybe just clarify the issue of the state security.
I think it was yesterday, when we became aware that Professor Kulu has issued a press release and an affidavit saying that he is being harassed by state security. The law says when there's a breach, you need to report. There was a security breach at the Civil Rights Commission where we've got a group of commissioners where we normally have debates and discussions internally. One of the emails which had been written by a commissioner who happens to be an advocate as well was then found on social media, having been placed there by Professor Kulu. This was to do with the legal opinion from Parliament. This was a conversation where commissioners were discussing the legal opinion of Parliament, but we then found that he had placed this on social media. The rules were governed by, we'll share our media statement that covers everything. We then are duty bound when there's been a breach to report to state security that people were assigned to the CRL for information integrity. So whenever there's a breach, we have to go and tell them that there's been this breach. We don't know how it happened. They will have to then go and find out what happened. Apparently, one of them, the agents, had a conversation with Professor Kulu about that breach. And he then interprets it as the Civil Rights Commission setting the intelligence operations on him. The Civil Rights Commission does not have that power to control intelligence, because then that would be absurd. We simply follow the rules. If you have a breach, inform us. They've done comprehensive presentations to the Civil Rights Commission in terms of risks, etc. And that information integrity is very important. We simply said to them, here's something that is now on social media. We don't know whether our server has been hacked, because that's also a possibility. But this is the person who posted this internal communication to the country. That's what he was reacting to, that the people from SSA, State Security Agency, had contacted him about the email from the CRL Commission that he had posted on social media. It's him who needs to explain his discussions with the SSA. We're not party to that. All we explained in our social media, which were in our press release, which we'll make available to Sharon to distribute, simply articulates what the rules say if there's a breach. And that we followed those, and they've been doing their own investigation. They'll come back to us when they're done with the investigation. I'm not sure, Honorable Chair, if that covers it. Or the complaints, oh yes, sorry, Honorable Chair. The complaints that were submitted by members of the Section 22 for Christians can be shared. That's why I was saying the members themselves can be best placed to explain what was happening there, because I was only brought in when the relationship was breaking down. But those complaints can also be submitted to sharing for distribution.
You could just highlight
Okay.
without going to all the detail. We're not going to be asking each and every member to say what was your complaint. We just want you to, what did you respond to? You had certain complaints placed on your table, and that's what we'd like to hear about. And then we can get the details in writing.
Thank you, Honorable Chair. The complaints were mainly around the fact that Professor Kulu was allegedly bullying the members into adopting his white paper. I said earlier that I was asked about this white paper in this committee as to whether the CRL is now in the business of passing legislation, which I said we're definitely not in that business. We're not empowered. We're not expected to do that. But the complaint was he is forcing the members to adopt this paper that he has developed alone, and says to them, the chairperson of the Civil Rights Commission has agreed to this white paper. That was the main thing, and that when they were interacting with him about, we don't want the paper, we're going to write our own and then release it to the nation, which was done in December last year. He objected, saying he's a professor, he's got 3 PhDs, etc., etc. So that discussion degenerated, and at some point, the others decided to march out. And then they said to me, you need to intervene because he is saying you have agreed to this white paper. Then he must say it in front of you that you are the one who agreed to this white paper. So I attended their 2-day meeting, which was for the first time because I had been told, come and see what is happening there. Throughout the 2 days, as I said earlier, he sat next to me and he said absolutely nothing. The work continued in writing up of the paper that they released, if I'm not sure, on the 19th, if I'm not mistaken, 19th of December. And that's how he then became worse, as they say. And then the issue of him having a press conference to discuss Section 22 matters, I think that's when the relationship totally broke down, because they then said, what are these issues we are calling a press conference on? They then passed a vote of no confidence. I wrote to Professor Kulu and informed him that he cannot address that press conference as the chairperson of the Section 22 committee, because he doesn't have a mandate from his members, and they have no idea what is this thing is going to be addressing. And they've passed a vote of no confidence. At that point, the night before the press conference, he sent me his letter of resignation. And that's what brought the resignation issue, that he was having a problem with the other members of the Section 22. He was not dealing with their grievances about the white paper. And also I raised the issue with him, Honorable Chair, I don't know if you still remember. One of the members in this committee said the CRL is now in the business of passing legislation, and they now have a white paper. That on its own was bringing the CRL into disrepute, because we are very much aware of our limitations. Our Act says we recommend to the relevant authority that there's a need to legislate around this issue. And the relevant authority will then do all the necessary things, white paper, bill, etc., but not the CRL Commission. So he had already overreached his powers, which are very limited, really. It was just to consult with the rest of the nation who are Christians. So that's what brought about the complete collapse. And I must say, Honorable Chair, that he hasn't been truthful about what happened. He insists that I was in those meetings throughout. I couldn't have been sitting there with him pushing a white paper in front of me. When the white paper eventually came to my attention, I discovered that he had put a logo of the CRL Commission on that white paper. And that's when I understood that the honorable member who said we have a white paper had every right to say so, because there's a logo of the CRL Commission attached to this document, which is also illegal, to say the least. You can't have a paper that you write, he said was writing it with his other friends who are professors and other colleagues, and then simply going to the internet and put the logo of the CRL in that document. That has nothing to do with the CRL Rights Commission. That then brings the CRL Rights Commission into disrepute, that not only do we have this thing, but we're lying about having it. So that for me was also a breaking point, because academics have a right to write in their personal capacity whatever they want to write and propose, but they can't drag the CRL Rights Commission into that. So in summary, Honorable Chair, that brought down was the cause of the breakdown. And then yesterday's attack on me and the state security agent, it's for them to defend themselves. We've got nothing to defend there, because we followed the act and we said there's been a breach. That's all that we said to them. We wrote a letter to them, which we're willing to share, that there's been a breach in terms of information.
That's fine. Thank you.
Okay, thanks
Yeah.
a lot, Honorable.
Just
Chair.
for my own understanding, you said there was a document drafted in December. What is it called?
The document drafted in December by the Section 22 committee is the framework that they are currently using to consult the religious sector.
Draft self-regulatory framework for the Christian sector in the Republic of South Africa.
Yes,
Okay.
Honorable Chair.
All right, let's fine.
Okay.
Honorable Ndamase. Let's move to the next one. Honorable Mtolo.
No, thanks, Chair. No, Chair, I would like to take you back. You will recall that actually we had
a presentation from CRL Commission dealing with their budget. So the issues that were raised or concerns that were raised, are we at liberty to raise those issues in that meeting while actually we have CRL with us?
Let me let me start it this way, Honorable Ndolo. Chairperson, we had a meeting which was virtual with the minister, and you were present. And we asked you to comment, and you said you are not prepared to comment because your legal opinion was to the effect that you shouldn't comment. We're dealing with trying to understand what is the fight and tensions that was about. And the minister was there indicating what their roles were in relation to the CRL. And then we then asked you for a comment on these issues. Does that matter? Does that issue, look, the matter is still in court. Does that raise the same question, or have you changed? What was your legal opinion about in this regard? Does it make you free to continue to talking to us?
If you remember, Honorable Chair, in that meeting, I said we're willing, more than willing and able to continue engaging with the portfolio committee, but not to deal with the facts tabled in the High Court or the Constitutional Court, but the generic engagement that we've had today that does not talk to the legal questions that have been tabled in court in the two High Court cases and one Constitutional Court. We've been told don't get into these details, but you can discuss, like we did today, the framework, where we're coming from, and the both CRL Commission Act framework, the constitutional framework, but not to delve into the case of whether the Section 22 ad hoc committee should continue or not continue. We are saying whether that continues or not will be guided by the courts, and we cannot engage on arguments that will affect the court cases. Because right now there are 3 court cases that are running.
I might just be the one who's getting a bit confused. The presentation by Advocate Zulu was literally dealing with the issues around the matters raised in that court issue as well. I'm not disagreeing with that. We must talk about them. I'm just worrying about the fact that I don't want us to have hide and seek, where when we go into what you have already tabled here, then you start saying, well, this is in a matter of the court, because all the issues that have been raised here are aligned to what is the purpose for our discussion today. Some of them are issues that are arising from the court. We're not dealing with the court papers, we're dealing with the issues. The issues would be the same, but in this case, there's already been 30 minutes presentation on this issue, which is illegal. That's why I asked you the question at the beginning, what is this presentation about? When I asked, that was the reason. So, can you set us free? Let's hear where we are.
The presentation have been tested by our legal people to look at whether they will not come back to bite us when we go to court. One of the things that the legal people have told us is that you must always be conscious that whatever you say will probably be tabled in court. A few weeks ago, we got new papers from the South African Church Defenders where they were highlighting a few things. retabling the matters in court. So there are issues that are alive in court, but there are factual issues that can never be a court issue, like our proposal that we continue with about self-regulation. So the articulation was about self-regulation versus state regulation, but also the issue of individuals, religious practitioners. So we're walking the thin line around that because the lawyers have given us the thin line to walk. At that point, they had said, we haven't workshopped you. You should stay away until we know what you're going to say and how you're going to frame it, and then we can move forward on that. So on the issues, Honorable Chair, honorable members that we have tabled, we're fully willing to engage in them.
Okay, let's come back to Honorable Mtolo. My view, though, is not a thin line. I think your line is very wide, actually. The way you have dealt with issues, it's actually. But let's come back to that later. Let's come with Honorable Mtolo.
No, thank you. No, Chair, I'm not trying to be personal here, but I would like actually to ask Advocate Zulu her position within the CRL, and also inquire whether he is registered with the Legal Practice Council, and actually whether before the committee comes here, as the chair has actually outlined that usually they were advised, was she also part of that advice before coming here? Why I'm raising that issue, Chair, is because of her presentation, because her presentation was detailed. Thank you, Chair. I then actually make a follow-up.
No, I don't think it's personal. Let's be a bit more direct. Chairperson, I've actually asked the Secretariat to give us specific designations of the individuals who are attending. We've just got a list. I missed it as you were doing the presentation. It does become important as we move along so that we don't misunderstand each other. So I don't know whether that's still possible to I'm not saying you introduce, but if somebody can just send us that so we can match who is who in the process of our conversation. I don't know what was the problem. I'll leave the blame on the Secretariat, but I've asked her 3 times for this, and we didn't quite get it. In fact, we did not get it. All we have is a list of names, and sometimes all you will have is that we've got the chairperson, we've got the deputy, and then, so it's a bit difficult. So we do want to understand a little bit more as we move into this discussion. So I would like the advocate to answer the question for us. Thank you.
Thank you, Honorable Chairperson. Yes, Honorable Mtolo, I am registered with the Legal Practice Council. I completed my pupillage at the Society of KwaZulu-Natal of Advocates. With regards to the advice that was given, I am a part of CRL's legal internal structures. And so the advice was given by external counsel, senior counsel Ramulife, and he is the one who had provided the advice that to not get into the legal minutiae of what's currently before the court. But what's in my presentation is just an overview of what our position is, what our arguments are, and not necessarily what is being argued before the court in specific detail. I don't know if that covers.
It does. It does, because we just want to understand. Before we go into the details of what we have, we want to understand the environment under which it's been tabled. It becomes very helpful for us. Then we don't misunderstand each other as we move along. I think for now, that answers the one question. Let's just take it on from there.
Chair, The reason why I'm asking this question, you will recall that actually we also touched on the budget of the commission, our engagement. So we also discussed the staff complement. We also discussed the human resource budget percentage, where we raised a concern of I think it was above 70% human capital budget, where we requested more information to be provided to us. And then we were then promised, I think by the deputy chairperson, that that information was going to be forwarded to us. I'm trying to check, Sharon, whether that information has been forwarded, because I don't remember that information being shared. And then we also indicated the sense of urgency, in getting that information. Take, for instance, tomorrow share will be dealing with the budget vote of the department. So, and then it would be very much informative for us actually to have that information, so that when we make input, at least we know about those details, So I'm trying to check actually whether that information, because the deputy chairperson did promise that actually was going to forward that information to the committee as concerns were raised in that meeting. Thank you, Chair.
Okay, we're gonna check that on the secretariat if we got that information. We'll have to come back to that. We'll get the secretariat to check that, and then we can come back. Honorable Nkosi.
Thank you, Chair, Kabazela. Let me start by thanking you, Chairman, Chairperson Togo Mkhonazixwaluva, and especially at Advocate Zulu, with a very comprehensive presentation. I think that from my side, Chair, the one thing that I find is an overriding sentiment, or rather accusation, for lack of a better term, especially against the chairperson, is the overreach. That's what we find everywhere, that it's not so much. I think a great effort has been made to try and close all the loopholes, if you look at this document, which is great. Now, you said, Advocate Zulu, that if you regulate that doctor,
Recording stopped.
actually happening here. And that was what we came up with. And then the issue of mainline churches, Honorable Nkosi. We had a very long discussion with the South African Council of Churches because they all fall, under the South African Council of Churches. And we've discussed, what we are saying, Honorable Nkosi. Mainline churches have had a system for decades. They identify their people, they train them, they allocate churches to them, they monitor them, they discipline them, and they've got a tight system. That is the system we hope can also apply to Archbishop Thoko Mkhwana in her tent in Mlasi, where she has put up the tent. I'll be open with you, Honorable Chairperson, honorable members. We know where the problems are, where there are stand-alone churches with no framework. The mainline churches, we said to the SACC, we are part of Section 22 committee to protect the interests of mainline churches. So whatever you come up with should protect existing systems and not destabilize them. So we're very much conscious of the fact that the majority of mainline churches are doing the right thing. There may be problems here and there, like we know when boys have been violated and the system did not support those boys, but those are exceptions to the rule. But as you rightfully say, Honorable Nkosi, the mainline churches have got a system that works effectively most of the time.
Okay. Let's get the next question, but just to understand what you're saying, Chairperson, in the case of the boys who are molested, the system didn't protect them, and you say that's the exception to the rule. Are we saying that the reverse is true for the rest, that the abuses are generally found and representatives of those who are not part of the system?
What I was trying to articulate, Honorable Chair, is that, for instance, there have been serious breaches in the Catholic Church all over the world. The allegations also about the Anglican Church that are being addressed or have been addressed by the various mainline churches. But what I'm saying is the danger and possible harm is much more contained in mainline churches than in standalone churches. But there have been reports about boys who have been violated in the Catholic Church, but also in the Anglican Church. Not fully spread, but there are reports from the US, the UK, a church here, a church there, a church there. Hence, I'm saying they're an exception to the rule as opposed to blanket risk.
You know, and members want to ask further questions, but there's an issue in this statement you are making, and I want the commissioners to come out on this. Your issue is in the Orthodox churches or the conventional kind of churches, you've got problems, but they are an exception. But you are saying it's the other way around. The problem is much bigger on those other churches that are not part of the mainstream, on the mainstream churches. Now, do you have a sense of percentage abuse we're talking about? Is it like it happens in 90% of them, it happens to 5% of them? And I'll tell you why I've got to ask you this way. Was the way you're putting it, you're telling us exactly where we're actually feeling that the problems are coming. So, and I do want the commissioners to be alive as we ask the question that when we say the issue of abuse, we're not disagreeing. The question of the abuse in relation to whether these are mainstream churches or whether they're not mainstream churches, is it the same or is it different? And that's the problem.
Okay, Honorable Chair, I was taking from what Honorable Nkosi was saying about the comments from the mainline churches like your Anglican, your Methodist, etc., etc. What I'm saying is that the mainline churches already have a disciplinary regime that is there, that is followed when there's been a breach or where there are suspicions of something going wrong. I'm basing this on the experiences we've seen where, for instance, a particular religious leader, there have been complaints about that particular religious leader on sexual violations. The young people go to open cases. One is in the High Court in Pretoria. The religious leader accused by several, I think if I'm not mistaken, is 12 young people of sexual abuse. He is granted bail. He goes back to church every Sunday or even during the week. He climbs the pulpit. He goes back to the crime scene, so to speak, because the allegations are that that's where the crime was committed. I'm then comparing that to my own church, to the Methodist, for instance, Methodist Church, that if you've been accused, as an example, the Methodist Church, one of the mainline churches, if you've been accused and charged of such criminal behavior, they'll probably suspend you. They won't say, oh, now that you are out of bail, Mfundisi, you can continue as usual. So I'm doing a comparison of the one that has systems of disciplinary in it and of the other where I own my church. I started my church and I'm out on bail, for instance, but I'm back in church. So I was saying in the mainline churches, there are systems. That's why I was saying the South African Council of Churches, which has membership of the mainline churches mostly, is part of the Section 22 committee to look at those. How do you advise on how the other system works? So I'm saying the other system has checks and balances. You can't be out on bail and the next Sunday you back in church. In the mainline churches, it wouldn't happen.
Okay, so you are then saying the mainline churches are sorted, the others are not. So the Section 22 is about sorting those, and then the mainline churches will assist them. It's very important for us to understand, because there's a misunderstanding that we are trying to follow. And when I'm trying to listen to you, I'm hearing it differently each time you explain, because the basic question was, let's take the churches. You got so many churches. What level of abuse are we seeing? Are we seeing 1% of church leaders being involved in abuse, and therefore we're saying we need to zoom in onto those, or we're saying there are churches that have got 1% and they've got systems, they can deal with it. There are others where we've got 80% of abuse and they have no system. That's what I'm trying to get. What are we curing here? Not that we are questioning that there is abuse. The issue is not the question of abuse. The question is we're trying to understand how you are going about it, and that's for us where the main difference is. It's not a question of where the problem started, it's how you are going about it. So that's why I need you to clarify those issues. Then look, let me leave you with that. You'll answer it in line with the other question. Let me get the next question. Yes, thank you.
Thanks very much, Honourable Chair, and good afternoon now to my honourable colleagues and to the Chair, CRL, and others who are here present from the leadership of the Commission and in supportive roles. Thank you very much for your presentation. It's been very interesting, and I've been somewhat looking forward to the opportunity to engage in this. So thank you. My first question relates to a survey on the status and experience of the rights and responsibilities to religious freedom within the faith communities of South Africa. And that perhaps picks up on the Chair's point here about trying to get a handle on the evidence. The survey ran over many years. I believe thousands of organizations were consulted, and there was obviously quite a significant cost to the state to produce that survey. And it was meant to gauge public sentiment, gather data on religious practices, address concerns about the erosion or regulation of religious freedom in South Africa. Questions which are very relevant to these things that we're discussing here. And the assurances were given that the survey would be made public, and that was at the National Consultative Conference. And given all of the expense of this and the time and the effort that's gone into it, why has the survey not been made public? And I would like to request that it is made public, or at the very least made available to this committee, so that we can be aware of the full evidence that has been gathered as a result of that public process, and good reasons why it hasn't been made public to me. The whole Promotion of Access to Information Act, if you think about it, was designed that we wouldn't go back to the deep, dark old days of apartheid when everything happened in secrecy. So I trust that this report will now be made public within a very short time. Thank you. Thank you, Chair. Secondly, as the Democratic Alliance, we affirm the individual freedoms which are protected in our Constitution, the freedom of religion, of belief, of expression, speech, freedom of association. And we don't pay lip service to these rights. And that's why we led the charge against the Chair's attempts to bring about this legislation in the fifth administration. And it's why we continue to reaffirm our opposition to the regulation, and why we will continue to oppose it. The crisis is not a lack of laws. It's a lack of enforcement of the laws that we already have. We have a crisis in SAPS, which is very visible, very well known. We have problems with the NPA. We have problems in our courts. We can't enforce the laws we have. We can't see that there's justice where those existing laws are broken. Adding reams of new laws is not going to fix that problem. In some ways, it's going to make it worse. It's going to make an increased regulatory burden, because all of those laws will then also require their own systems for enforcement and for accountability. And we're making 99 good sheep jump through hoops for the sake of one bad sheep, so to speak. And so what we need to do is look where there are existing laws, civil damages, and trying to work out ways that we can make sure that there's proper accountability for religious practitioners who don't obey those laws or who do cause damage. And I've listened to the many specific situations, the many cases that have been raised here, and to my mind, it all comes back again and again and again to this issue. But even if there are gaps, and you've made the assertion that there are gaps, let's rather address the gaps. We can address gaps, that's easy. It doesn't mean we have to create a whole new regulatory environment with more hoops for everyone to jump through. And this really just touches the whole of society. It's an enormous endeavor, and that's costly. And that cost is borne by all South Africans, and it really doesn't seem to me to be necessary or justified, given my preceding comments. We also need to consider, in terms of the consultation process, there have been a lot of objections that the process has been rigged, that there was a predetermined outcome that you were aiming towards with this whole thing. You tried to sort of silence and sideline dissenting voices. Some of your methods in engaging with dissenting voices appear to have been open to challenge, shall we say. So the process has been challenged in court. It is being supported, as you pointed out, by some mega churches and some large mainline churches. But I think one must also be aware that the mainline churches and the mega churches are often losing market share to smaller up and coming churches, so to speak. And so in some ways, having heightened regulation around the way they do things is a way of creating a kind of a moat to defend their own territory and their own turf. And so one also needs to be aware, I think, that their participation might also be affected by some of those factors as well. And if one considers the landscape of religious freedom and the protection of religious freedom, and respectfully, that is primarily your mandate, to protect the constitutional rights. The greatest threats to religious freedom, if you look at it around the world, it's not the religious practitioners, it's the state. It's governments that oppress religious freedom. That's the greatest concern in this whole situation. And it seems to me the greatest challenge that the CRL should be concerned about. And so in the context of South Africa, those concerns are amplified because of the ANC's close ties with China, with Russia, with Iran, all of which are highly repressive when it comes to religious freedom. And so there's a great deal of suspicion amongst the South African public about this, that this is not a national security threat. It might be an ANC security threat, but it seems like it's not at all a national security threat. And so, and on this point, the concern about abuse by government is further amplified by the inclusion of charismatic and Pentecostal churches as a priority domestic terrorism and national security concern in the recently published National Security Assessment Report, National Security Strategy 2024 to 2028. I mean, you can't make this stuff up. To me, that seems to be extraordinarily prejudiced and unsubstantiated. And one can only question what level of ignorance or prejudice or ulterior political motive underlies that. It needs to be removed from that report. I realize that's not within the CRL's realm of authority, but certainly some serious evidence should be presented before making a statement like that and including it in a national security strategy. And then let me also add this, despite the protestations of the CRL, I find it very hard to imagine how this will not result in practice to serious violations of the constitutional protection of religious liberty in practice. And it will certainly open the door wide to future abuses of that, of the right to religious liberty. And let me also just say this, I think the CRL's efforts and all of the cost of this whole process would be far better expended in trying to educate the public and warn the public about the abuses of pulpits and other kinds of abuses that can take place. And also to encourage and reward and recognize voluntary self-regulation where it exists. So where there are concerns about inadequate governance, and that is a real issue. I'm not disputing that. That is a real issue. Governance is important, and there does need to be good, strong governance in churches. But rather put the emphasis on trying to highlight where that is being done well and highlight where it's not being done well, rather than trying to introduce a whole massive regulatory regime. On the next, sorry, Chair, it won't be too much longer.
I hope you close.
Okay.
I hope you do.
I'll do that. I'll be as quick as I can. It's been suggested by that the CRL should pause its work pending the outcome of the court cases. And because if the court cases are successful, that'll bring into question the legitimacy of all of the outcomes of the process. And also it'll cause fruitless and wasteful expenditure. And in the presentation, you characterized or you stated that pausing the process or resolving not to entertain the outcomes of the Section 22 committee would mean that Parliament is, I quote, opposed to accountability for spiritual leaders. But that's actually not correct. The question is not whether or not spiritual leaders should be held accountable. We all agree that if there are abuses and criminality, they should be held accountable. The question is really rather why, and how should they be held accountable? What's the most appropriate accountability mechanism? Whether an additional regulatory framework is justified. And fundamentally ensuring that the process by which we answer that question is robust, both in the eyes of the law and also in the eyes of the public. That's been generated because of the fact that the process is not perceived to be robust, and the court case will tell us whether or not it has been. And so there's a great deal of controversy and distraction. I'd like to propose to this committee that the committee should resolve not to entertain any report or outcome from the CRL until the court case has been heard and the court has ruled, or a process can be started from scratch if that is what the CRL would like to propose, but it needs to be done in a way that's legitimate in the eyes of the law and in the eyes of the public. Thanks very much, Chair.
Okay, no, thank you very much. Let me say, Honorable Bateman, you have raised a number of issues, but let me start by going back to something that was outstanding. The committee requested that that we should be provided with a proper response explaining the reasons for spending over 60% of the Commission's 49.6 million annual budget on employee-related costs. The budget should be properly disaggregated to demonstrate the skills available and the salary compensation due, as to provide the sense of the reasoning behind arriving at the staff complement of 38. That was the committee decision. Now, I said to Honorable Mtola, I'm going to check. We haven't received any of that information. So I will need you to provide that information. We need it because we're going to the meetings tomorrow. There was also another request that we made, Chairperson, and this goes back to the meeting we were supposed to have had with the Speaker, the list of your database of the religious leaders that you've been dealing with. We've only got a list of about, 20 or something, but I've seen a number of those that are in the list on your report. I actually don't appear in that list, so we need that list as such. But let me come back. I'm going to excuse you from responding to some of the comments made by Honorable Bateman. Now, I think Honorable Bateman, it's the first time in this committee we have politicization of attacks on the issue of the CRL. We have all raised views in terms of what we think is best for the for Parliament, for the people of South Africa. But we've never gone party political in the way you did. And I'm not sure where all that information has come from. I'm a member of the ANC. I don't know any of the things you're talking about in terms of the approach of the CRL is not based on the alignment of the ANC with China and any other issue. So that's completely incorrect. And I don't want this committee to get to entertain that direction of issues. There are concerns that this committee has in relation to the approach on this matter. We actually want to get to that level of those, but the party politicization is not helpful in this case. So I'm not going to request that anybody must respond to those aspects. But the Commission can respond to the issues raised, cut out the issues about the politics. I'm not sure any of you are members of any party, nor do I care. Even if you were, and if you go the direction you are taking, would not be interested. So I think you must just be clear. Don't start getting tempted into exposing yourself, whether you are MK or DA or whatever. I don't want us to go in that direction. We'll be losing direction. The issue is the approach of this commission in relation to this section 22. There are issues here, and they're not party political. Let's deal with them that way. So please respond, then we'll come back to the next issues.
Thank you, Honorable Chairperson. I'll cover as many, there were many issues, then I'll ask the Deputy Chair to fill in and other commissioners to fill in some of the gaps that are in their area of operation. For instance, the issue of the Honorable Member said there must be education of the public. There are commissioners here, and the chairperson of the committee that deals with public education and advocacy, Commissioner Makoboga, who chairs that committee that deals with public education and advocacy. The issue of addressing the gaps, Honorable Chairperson, Honorable Members, is what got us here. That's why we're to start way back in our presentation and take us to where we are. There are a few realities. One of them is the regulations, although lapsed, about self-regulation and a code of conduct supported by legislation. Those came from this committee in 2018. Then there's the issue of sidelining dissenting voices. The Civil Rights Commission has been deliberate in saying meet with the dissenting voices. 2 weeks ago, the Section 22 committee met with Freedom of Religion South Africa. They met with the church defenders, who are taking us to court, by the way. So the issue of saying was sidelining dissenting voices is not a reality. We are basing this process on, we may have over 40 million people who agree with the proposals based on the mega churches and the umbrella organizations like the South African Council of Churches. But we said those that are opposing should be the first people that the Section 22 committee meets with. We have said, for instance, those that are calling themselves anti-regulation organization, they were also on the first consultation process. So you don't start with people we are said to be sidelining, and you prioritize meeting with them. If you sideline people, you push them to the back. But they were the first in as the first people to be consulted by the Section 22 committee. So it's not factual that they are being sidelined. As the Civil Rights Commission way back last year, we met with Freedom of Religion South Africa, Michael Swain and his board. We made a presentation to them. We agreed on one major thing that even Michael Swain himself agreed to, that there must be vetting. we walked away with that agreement. And vetting doesn't happen in a vacuum. Vetting happens within a system that says, if you are found on the list of the Child Protection Register, then it means you can't work in this sector. They agreed with us on that one. But to get to the point where you vet people, there's a process, because you must then know the fingerprints must go to Pretoria, but also there must be consequences where, oh, unfortunately, you were found guilty of raping a child in 2000 and whatever, so you can't continue in this sector. Those are the gaps we're talking about, Honorable Member, that there are serious gaps that they themselves, the people who totally oppose us, I can clearly say that in public, they agree that religious practitioners ought to be vetted. That's just one example of us saying we're not marginalizing anyone. I'm sure we are aware that force opposes everything that we do, but they were one of the first people we spoke to were accused of marginalizing charismatic churches. The first person we met with is the Secretary General of the International Federation of Charismatic Churches, Pastor Giet, and said to him, this is what we would like to do. As I said earlier, Pastor Ray Macaulay used to play that part of us bouncing ideas on him as someone who was leading charismatic churches. Unfortunately, he passed away. May his soul rest in peace. But the IFCC, they were the first people we spoke to. And at that point, they said, yes, this is a new approach. We are no longer doing what you were doing then. Yes, we support this. And that is public knowledge. I've said it in front of Pastor Giet. He agrees that he was the first one to be consulted in this country. So we're not sidelining anyone. It's not factual. The fact that mainline churches are defending their territory, it's not sustainable as well. The mainline churches are still the biggest. For instance, the SACC has membership of 16 million. No other umbrella organization can pull that off. But the issue of saying this is more like a business, you're stealing my clients, etc., I don't think the mainline churches are sitting somewhere thinking this is a territory war. They are there as part of Section 22 to protect and defend the rights of mainline churches. TISA is there to defend the rights of evangelicals. So we didn't just do a random thing. We went to the critical people to say, if we were to propose this, would you support us? And there was an overwhelming yes. As you saw the numbers, they are verified. When you have a footprint of over 40 million people, they can't all be wrong. There's another allegation, Honorable Chairperson, that the CRL wants to do what Rwanda has done, to say you must have this kind of building, you must have paved parking lots, you must have so many windows. You don't bring in abantu bakwaShembe no ZCC to come and talk about buildings, because they don't have buildings. Even Amazayoni do not have buildings. So we're far away from that. I think, which I should state, Honorable Chairperson, there's a mistrust, trust deficit that makes people to say we're doing things that we have no intention of doing. Who advocate Zulu touched on issues of misinformation and disinformation. Unfortunately, the technology did not work because those were going to prove beyond reasonable doubt. We're hoping we're still going to be able to make the system work, that they crop videos to push a particular narrative. They deliberately make me look like a mad woman who is antichrist. So there are all of those things that are built into this discourse that we shouldn't be confused by the issue of the state oppressing religious freedom. It can never happen in South Africa with the kind of legislation and constitution that we have. The issue of freedom of religion, we've said it many times, it's sacrosanct. As a result, we're talking to one of the universities to say, can we pull legal professors who are experts in the constitution all over the country to a conference to deal with one issue, Honorable Chair? What is freedom of religion? Because where we're sitting, we say to people, we guarantee your freedom of religion. What do those people understand by freedom of religion? We are saying we must retire from determining those issues. What does it mean when Section 22 of the Constitution says you can choose a profession, a career, or a trade, but that may be regulated? We want them to look at issues of human dignity versus freedom of religion. We want them to look at when is there an interface between freedom of religion and violations of some of the issues that are in the Bill of Rights. So we're not going into this thing with a mono kind of interpretation. When we are willing to expose yourself to professors in terms of experts in the constitutional analysis who train others to do that, then everything is out in the open then. We are talking with one university and we intend doing that before the end of the year. The issue of, I won't touch what I've stated, there's repressive states all over the world. National security strategy that says charismatic and Pentecostal churches are a risk, a security risk. When the national intelligence and other people who determine what is a security risk in the country, they don't consult us. I'm sure they don't consult government. They produce their own that we're also looking at as, oh, okay, so this is what they've identified as a security risk in the country. The Rights Commission was not even consulted. We cannot, and we've said this several times, I know freedom of religion, South Africa has raised this many times. I know Professor Kulu raised it just the other day in his press statement. The Rights Commission was not involved in the writing of this national security strategy. We were not even consulted. And I think, Honorable Chairperson, it would be an overreach for us to go to them and say, can you remove this clause here? We don't like it. Would be totally out of order. They do their own thing and they make their own decisions. I hope this will rest this matter, forever, because it keeps being raised. Even Professor Kulu in his statement raised it yesterday. Every time I'm in a room with FOSA, they raise this issue that go to national intelligence and ask them to remove us there. We can't. Violations of freedom of religion were very much conscious and cautious that we shouldn't. Education of the public will have a special unit that deals with public education and advocacy. There's a unit of officials and also a Section 22 committee of commissioners who specialize in nothing else but public education and advocacy. So it is a priority for the CRN that we continue educating the public. There are people who say the Civil Rights Commission should pause its work. And I think even the legal opinion from Parliament addressed that issue and was saying that several mechanisms were told by our lawyers that they can go on and interdict. They have that option to go to court on an interdict and apply to interdict the CRL from doing its work. As advocate said, we will defend our proposals. We're not going to lie back and say, okay, interdict us. That's not what we're saying. But there's no interdict that's going to stop us. So we need to continue because we only have 5 years and we've got a strat plan and we need to do these things accordingly. And then there's the issue of robust debate. We're all for that, honorable member. We're very much all for robust debate, but it mustn't involve insults. That's a no-go area. When you personally attack me and say, Lo Mamu Isango, she hates Christianity. I'm a full-on Christian, baptized, confirmed, and practicing. When you start going that far, then it's not robust debate, is it? Then it's something else. When you crop videos and say, I'm saying people must wave their underwear in the air, knowing pretty well that your main member, a member of the church defenders, is the one who was saying, Prophet Mboro, that people must wave their underwear. There's proof beyond reasonable doubt in those clips that are not playing now, which I hope will be circulated to everyone to listen to. They're very short. We know what we are busy. Robust debate does not involve insults, disinformation, untruths. Robust debate is about dealing with the issues on the table. Differ with the CRL Commission. That's what democracy is all about. March if you want to. That's a hard-earned right. But don't tell lies. They are not part of the equation. You cross the line, and the church defenders have crossed the line. The committee should take a decision not to accept any report. It's out of our hands, Honorable Chair. We have no comment on that. I think you were not necessarily addressing it to the CRL Commission. I don't know if we still have time, Honorable Chair, or whether one of the commissioners.
Can we deal with that budget
comment?
story and get it out of the way? What's happened?
The what?
The budget issue. Can somebody
Oh,
deal
the
with that?
budget
Yeah, and
issue
get it
is
out
with
of the way.
the
And the list.
CEO.
And the list, and then you can see if there's outstanding issues. We'll be coming to you.
Okay. Thank you, Honorable Chair.
Good afternoon, Honorable Chair, honorable members. The list we have started sending, we will fast track that. We add the other members.
Okay, let's put it, make quickly. Just give us the timeline so we know how long to wait. We waited for a while.
I think by Friday we'll do that.
Then we say, are serious? I mean, you have an administration, you got the list, you got a database, you got your staff, you got everything. Why must we wait for Friday? This thing has been going on since around the Easters.
We thought
Let's just not make it an issue. I just wanted to put it on record and move on.
We'll do that, Chair.
All right, let's make it end of the day. You will give us a list. Let's close that.
End of the day, Chair, I'll still
Yes,
not
because
be-
we've got the names already in your report, but can't give us their contact details.
Oh, the 2017 report, the commercialization. Okay, no, we'll do that. So we thought it's something bigger than that, Chair. That's why we're taking time. We wanted to give
Okay,
you-
end of the day,
Yeah.
6 o'clock for you, Shirin? All right, let's do the budget issue. Let's move on.
So the budget is ready. We'll forward it to you now.
When?
Now.
Now.
Yeah.
Thank you. Honorable Mtalo, you want to follow up?
Yes, please.
We'll
Chair,
come to you, Honorable Francais. I just want to close this issue because it's been outstanding.
yeah, Chair, unfortunately, Honorable Member Ndamasa has left. I just wanted to make a follow-up on what actually he raised. Honorable Member Ndamasa raised the letter.
Okay, I'm sorry. I see what's going to happen now. You want to follow up on the other issue, not on the budget one.
Yes.
So I'm fine. You'll come back to that. There are
Okay.
more issues to bring. Let's finish off with Francais, then we'll come back. Yeah.
Thank you, Chairperson. Just very quickly, the Chairperson has said that there was a motion of no confidence against Mr. Kulu, and that she had written him the day before he resigned. Can we maybe get that letter that she wrote to him the day before he resigned? I'm requesting that, please. And then just quickly on, I know we've gone through the national strategies, national security strategy, and you've gone to lengths about explaining that you were not even involved, et cetera, et cetera. But the allegation in Kulu's letter remains that especially charismatic churches has been targeted by the ploy or the want to surveil. So if this committee, Chairperson, maybe through you also, can get all official correspondences between the Chairperson and the CRL at large with the State Security Agency, then we can sort of make up our own mind as to see whether, what has actually transpired, whether it was only reporting of a
Intelligence
breach.
Agency.
Yes.
National Intelligence
Yes,
Agency.
yes.
Yeah, that's fine.
But, if there was if they only reported a breach, or if there was actual, or if there's actual evidence to show that, you've asked for surveillance. Then the advocate made a statement that criminal laws are reactive when crime has already occurred. That was the point that you had made. I want to just ask a very simple question. Knowing that murder is illegal and a criminal activity, does it stop that from happening? It doesn't. So the point is that regulation exists, and it's again, as the Honourable Bateman had said, is that the enforcement thereof remains the issue. Because trying to over-regulate, that's what's going to happen. It's going to be over-regulated. And we know that there's norms, there's social circumstances that forces this to happen. By saying you shouldn't and you're going to get a slap on your wrist doesn't make that to stop. And I think you'd agree to that. Then the Chairperson keeps referring to Cheryl Zondi, because we saw that in the clip that was going to be the state, and that she was obviously the star witness in the Amatoso case. She has then gone on to have the Cheryl Zondi Foundation established, which is obviously to bring awareness of abuses in the Christian church. Chairperson of CRL, Mr. Kaluva, are you the Vice Chairperson of this organization, of the Cheryl Zondi Foundation? And has this organization received any state funding, national lotteries, et cetera, et cetera? And if that is the case, do you not think that there might be some conflict of interest? I'm just asking that could maybe from your point of view be raised. Then in 2019, the CRL convened the National Religious Summit at Rima, like you said earlier, and attended by more than 800 delegates, where the religious sector reportedly rejected the CRL's proposal for legislation peer review structures and instead developed its own code of conduct, if my information is correct, based on the Religious Freedom Charter. Why does the CRL continue pursuing regulatory mechanisms when the faith sector itself has already developed a voluntary framework? And I raise this obviously because the advocate in this ICR unit, I think it was said, raised this issue of self-regulation. Then the chairperson, the CRL has also defended the representativity of the Section 22 committee. But we know, as we've heard, the evangelical, the Pentecostal charismatic groupings representing millions of believers reportedly oppose and the process or not represented at all. I'm Afrikaans. And I can tell you that I mean, even though the South African Church Council is set as an umbrella body, historically there's been some issues with Afrikaans churches and that body as well. So I struggle to understand how this can be all-encompassing when churches also want to remain sort of standalone. And because that happens, and I think you are very much aware. So with that stated, Chairperson, through you, can the CRL maybe provide this committee with a full breakdown of which churches, denominations, and umbrella organizations formally mandate or recognize the Section 22 committee, the process, and which have withdrawn, which have objected, and which have rejected the participation? I think that would put to bed a lot of this. We are included, we are not, we are opposed, we are not. Thank you, Chairperson.
That last question is precisely the list that you're talking about. Yeah. So anyway, maybe it clarifies to make it easy, and when it comes, it should then separate, because basically we wanted to know those that have worked with the CRL and have said they agree. We also wanted those who didn't want, but a lot of them have come to us. And then withdrawals now, that's a new proposal. Who was decided, shifted, that's a new proposal. But the original list, I said we'll have it by today, but you can then expand it to separate just to cover this, because now it becomes more of a report than just a database. So you could proceed at that point with the responses. I'll come back to you, Honorable Mtolo. In the meanwhile, Honorable Nkosi is going to be holding the fort. Oh, yes, Honorable Van Veek, you will come after Honorable Mtolo. I note your hand on the platform. Please proceed. Thank you.
Honorable Chair, I should apologize. I did not respond to the issue of the survey, which was raised earlier. I'd written it on another page. The issue of the survey, the Civil Rights Commission, in terms of commissioners, met and looked at that report, and it was seen to have a few issues. One of them was that the reach of the people who responded, since this was an online survey, a lot of people were excluded. It was mainly in English online, which then meant the majority of people in this country were excluded. So the plenary of the CRL Commission took a decision to pull the survey back to first translate the questionnaire, which has been done by one of our language specialists, Commissioner Nkwe, and it's going to be given out in hard copies in all languages for people to then have access to it. So the report that I know Freedom of Religion South Africa has been after this report is not ready, since we need to make sure that people on the ground have means to fill in those forms, to be helped to fill in the questionnaire, and the questionnaire to be then analyzed. The issue of an online survey, it works, but it's a middle class problem. which the current commission decided it must go back and the questions be watered down. Commissioner Gavenda helped us to water down the questions, and then they were translated into all languages. And then they were made into hard copies and not online. So there's no survey result to release because it's still going to be going around to make sure that people all have a chance in that one. The letter of state, the letter we sent to the state security people, we can make it available this afternoon. Where's our, yeah, we can make the letter available that we sent to the security SSA to say there's been a breach and we're reporting this breach. So we can get that letter to you or to Sharon this afternoon. The issue of the Cheryl Zondi Foundation, Cheryl Zondi, I think it must have been 2018 or somewhere there, decided to start a Cheryl Zondi Foundation all on her own. She then approached me and asked me to be the deputy chairperson. She's the chairperson of the Cheryl Zondi Foundation. The Cheryl Zondi Foundation never applied to the National Lotteries Commission. The National Lotteries Commission for some time have had something when you go into their website where they were confirming that they've never received any application for the Cheryl Zondi Foundation. They've never allocated any money to the Cheryl Zondi Foundation. I know Forza Michael Swain had that poster of his where he was alleging that I facilitated that funding must go to the Cheryl Zondi Foundation, and then I inserted myself as the deputy of the Cheryl Zondi Foundation. The money came from the National Lotteries Commission. That was one of the insults I'm complaining about. I laid criminal charges against Michael Swain for criminal injury. We all know what is allegedly happening at the National Lotteries Commission. When you then say there was 1.5 million given to the Cheryl Zondi Foundation, in spite of the National Lotteries Commission having that poster that no money was ever given to the Cheryl Zondi Foundation. And then the issue of who are in support of the Section 22, I'm sure that we can do quickly the contact details of people who attended the 2017 National Consultative Conference. We have the names, and I'm not sure how quickly we can get to addresses because from 2017 to now, it's about almost 10 years, 8 years. People may have changed, but there are people we know from the list whose contact details can be easy to get to, but others, especially from provinces, etc., might be a bit of a problem. Some of the people who attended were government people. Some of them have retired, etc. So there are those few that we can't get to, but I'm sure this can be managed. To go back to the issue of a conflict of interest, when I'm part of any NPO, I'm also chairperson of the National Children and Violence Trust. I do a lot of community work. I help with soup kitchens and whatever else. So I am part of several community organizations, and Cheryl's on the Foundation happens to be one of them. I don't know if I've left anything.
Sorry, did you deal with the funds from state sources?
Oh, the Cheryl's on the Foundation. The Cheryl's on the Foundation is one of those that operate from self-funding. There's no state funding that it has received, and definitely not from the National Lotteries Commission. Yes. This can be confirmed with the National Lotteries Commission, of course.
All right, can we take the next questions? I'll take Mtolo and then Van Wyk.
No, thanks, Chair. Chair, number one, there's an issue raised by Honorable Ndamase, and I'm happy that Honorable Van Zulu Van Zyl has just raised it as well. So the issue of SSA. I would like to know actually from the chairperson, because there's also the information regulator with regard to issues of data and information. And there was also an option of reporting the matter to the SAPS. I would like to know actually why you opted for the SSA, that actually you should deal with the SSA. And then in terms of legislation, which law that actually you used or permitted the human right, the commission actually to go direct to SSA instead of going through the information regulation or SAPS. So that's number one. The issue of vetting, you raise issue of vetting several times. So I'm trying to check whether any one of you in the commission are vetted. And if you are not vetted, do you see the need of being vetted? Thank you.
Can I just do this? Honorable Van Wyk, you have a slightly different issue to raise. Can I allow you space? Will allow us to conclude this matter? I did ask that you should raise that issue with the CRL whilst you are here, but if my memory serves me well, you had a different issue. I just want to check. I'm wanting to get onto this issue now on the Section 22 committee, or you have a different matter, because I would still reserve that space for you. Honorable Van Wyk.
Honorable Chairperson, greetings and greetings to all the honorable members sitting on the committee. Greetings to the CRL Commission. Honorable Chair, no, I actually just had a quick question for the CRL Commission on what they have presented today, Chairperson. It's not about that other issue. So I just wanted to raise
That's
a question.
fine. Proceed then. That's fine. No problem.
Okay, Chairperson.
Yes, proceed.
Chair. Yeah, you. I just wanted to know from the CRL Commission, seeing that they have raised the issue of the language of the Khoi and San and pencil. I just wanted to know from them, Chair, can they please tell us, would they as a commission recommend that the language of the Khoisan should also be included in the Khoisan and the Khoisan and traditional leadership bill, Chairperson. Will they recommend it to do so? Thank you.
Okay, please note that question for later. You respond later when you are done with this one. Thank you very much, Honorable Van Wyk. We will then deal with that issue. Can we come back to the questions by Honorable Ndolo? And let me say, so that we can deal with the issue and kind of close it. Now, 4 members have raised the same issue about the intelligence agents. Now, the question really is, does the CRL in its day-to-day refer matters to the intelligence agency? Because what the members are trying to understand is, on the one side, the fact that you have sent some questions, some reports to the intelligence agency. On the other side, it seems you are dealing with a, let's say, criminal breach of security of information, which, as far as we would understand, should have actually been dealt with slightly differently. Or maybe if it's a criminal issue, it should have probably started with the police. Or maybe then in this case, member is suggesting information regulator in that system. Now, everyone who brings this issue is moving from the question of whether is there anything here, and you answer the question that you did not form part of the formulation of the threat analysis by the intelligence agents. The question is, everyone who keeps raising the issues is raising the suspicion about there's something underhand being done with the intelligence agency targeting certain people, targeting certain groups of churches. I think you need to open up and let's deal with the both. All these questions are taking us in that direction, and we need to openly put that thing on the table, because if you go back to some of the questions, the question arose from what was in the threat analysis. Now, you've at least expressed yourself on that. But let's deal with this issue so that you don't have to keep coming back to the different aspects. It started with Honorable Damase, came to Ndolo, came from Fancy, it came from Bateman. Let's just deal with that and put it on the side. Thank you. If you have got more people who can talk about it, let's just explain what is this relationship and what is this approach you are using, and how does the state intelligence get involved in all this?
Thank you, Honorable Chair. I think it's better that we zoom in really, because these things are hanging in the air. We have a normal relationship with SSA, and I think Mr. Smarts is the one who is, what do they call you, contact person or whatever. They have a system where in each, I think, Chapter 9 institution, where they train people about information security and what to do when there's security breach. With your permission, Honorable Chair, I'll ask Mr. Smarts, who's the coordinator, who attends their training, who understands the relationship that Chapter 9 institutions have with SSA in terms of information security. He is the one who can give more information with the chairperson's permission. Honorable Chair, I'll ask Mr. Smarts, who's the coordinator at CRL Commission with SSA, to explain precisely what is the relationship, what are we supposed to report to them? What are the rules? The rest, as I said, is clearly outlined in our press release we did yesterday. We'll make it available to Sharon before the end of the day in terms of who allow us to do this, what are our obligations, etc., etc. That can be made available in the afternoon today.
Can I just, before we proceed, Honorable will come in just now. Just explain who's Mr. Smart?
He is our CFO.
CFO.
Yes, but he's the coordinator. I don't know, maybe the CEO can explain
No.
how. Because it's-
Don't explain and say you don't know. You are the chairman. You are the
yes, it's
chairperson.
the coordinator, as I say.
Yeah, okay, CFO. He is also the coordinator with the National Intelligence Agency,
SSA, yes.
with SSA.
Mm.
Okay, so just explain how does, I mean, you just explain how the two links before we can listen to him.
Okay.
How do the two link?
There are two of them. One is Obed Simono, who are appointed internally to be liaising. They train them on security issues. SSA does this, I think, for government as well, for Chapter 9 institutions in terms of information security and those kinds of things. I think one of the things that I might have skipped was the issue of vetting of commissioners.
No, don't go back.
Okay.
You missed that, you'll come back to it. You see, from the start, we've been saying we need to know who is here, because we don't want to hook each other's legs as we move now, because we now begin to the question, what do you call do you have in the Section 9 institutions every what do you call CFO dealing with state security work? There's an explanation that we need before we can listen to the guy. That's what we're trying to get before we can go. You want to come in, because it sounds like you do get us a bit confused. We do want to know what is this link, because we don't understand that before we can even listen to the explanation.
I think it's the CEO's field in terms of deployment of staff.
CEO.
Maybe you can explain.
Okay, CEO.
Yeah, thanks, Chair, and thanks, honorable members. So the security assessments for institutions in government, it's a normal practice, just like audit. So they do on annual basis do come and assess if we have risks related to issues of security. And I want to believe that it's a practice also for government. I'm sure they do the same. They did not start now. They started maybe 7 years ago. They made assessment. They made us to change locks within the organization because they say they are not security inclined. They made us to buy some security detectors at the entrance of the organization because we did not have those. They said it's a risk. And they even recommended that we should actually employ a security manager so that our security within the organization can be managed. But because of, having insufficient human resources in the organization and financial resources, we are unable to adhere to some of the recommendations that they actually have given us, like employing a security manager. So, and that does not mean that we should not pay attention to the security issues that they've raised. So as management, we do sit down and say, how do we deal with these recommendations? Although we've got limitations of budgets and human resources. So we distribute some of these functions to other managers within the organization so that we're not left behind, but we are also, implementing the recommendations that they've given us. So that is the context in which the chief financial officer was appointed by myself to assist in terms of implementing the recommendation from the security assessments, including Mr. Simono. So we've got two of them assisting us.
Mr. Who, sorry?
Mr. Simono is the one
Sitting.
Yeah, he's actually a manager in my office, but also acting in public education.
Okay.
He's a senior
I
manager.
think let's hold on because that's the explanation we needed before we can actually give was CFO has nothing to do with state security issues.
Yeah.
But anyway, Mtwala, before we get in, so we can close this issue.
No, Chair. I would like actually Advocate Zulu to come in on this matter because this is a legal matter. It involves regulations and legal prescripts. And then we have actually a body that is with data and which is information regulator. And in this case, this body has now been mentioned because this matter has to do with data and information. And there's a body in terms of the law that actually deals with that. But it's surprising that CRL never actually contacted information regulator on this matter. And then even SAPS was never actually involved on this matter. And this matter was never reported to SAPS. They just went direct to SSA. So it raises eyebrows. So that's why actually even there are concerns outside there, and there are concerns even on the side of Professor Tulu, because you've been a minister, you've been a premier, I've been a mayor for a couple of years. Even at one stage, that actually in the municipality, I actually engaged with SSA on matters of information. So it raises eyebrows why actually CRL opted to deal with SSA on this matter, not information regulator or SAPS.
Okay.
Thank you.
Let's start with Advocate Zulu, then we'll come back to Mr. Smarts. Let's try and make it brief now. I'm trying to get us towards closing.
Okay. Thanks so much, Honorable Chair. With regards to compromised classified information, if a breach results in the unauthorized access, theft, or exposure of classified state information, which was what was now leaked, we have an obligation as a state institution to report the appropriate security issues to the security authorities in terms of the Protection of Information Act. So in addition, perhaps to the information regulator, the SSA is also covered in that, as far as my understanding is concerned.
Let's go back. Let's make it quick, simpler. Information regulator, SSA, you're saying both need to be informed.
Precisely, because it's state classified information.
So we're asking, were they both informed?
In this regard, only the SSA.
Let's hold it at that. Mr. Smarts, then we'll come in. Sorry, you'll come in after Mr. Smarts.
Okay. Thank you, Chairperson. Chairperson, just a little bit of history, because yes, it is strange for a CFO to be involved in security. That is true. The challenge for CRL is sitting in our capacity, the discussion that we have submitted the information for about our structure. So it happens that in 2017, around about there, SSA came to the CRL and they did a security assessment. In that security assessment, a few things were found. Amongst others, we didn't have a bag scanner at our door and things like that. Together with that, there's also a forum of security managers, which is run by SSA. And in that, there's a forum for SOE, state-owned state, but you know what I want to say, they call it SOEs. So in the SOEs, there's of all the different institutions, like your ESCOMs, your PRASA, your all the other, not departments, but all the other funnies, if I can put it in that way, has representation in that through a security manager. So we indicated to them that our capacity is limited, our budget doesn't allow us to expand structure. So then it was decided that for in the meantime, I will fulfill that role to make sure that we implement things that is communicated from security in the whole security cluster. So since then, I've been fulfilling that role in the CRL additional to my normal day job. So one of the things that they inform us about is what they call the MIS, Minimum Information Security Standards. And that is one of the documents that they, okay, and we also have a security advisor at SSA. We have a delegated person, each of the institutions or 2 or 3 institutions to one of the advisors. So I'm constantly in contact with the advisors. When they want information, we must do quarterly reports to them. We attend forum meetings where they disseminate information. They discuss matters like cybersecurity and the threat of terrorism and all those kinds of things is discussed in that forum. So when the matter happened, I engaged the security advisor. And then the security advisors advised me that, no, we can report the matter to them based on the MIS. So in the MIS, there is a clause that say security breaches must be reported to the state security agency. And that is how we got there. So there's no personalized attack on anyone or no sinister way of getting there. It was just by advice and discussing with the structures in place. What do we have neglected? I have to admit is we did not report the matter to the information regulator, but we will correct that and report the matter there as well. But we were advised by our security advisor that no, this is one of the routes that we must follow, and we followed that route.
Okay, that's fine. Let's get your comment next. Sorry, I need to get your name again.
Thank you, Chair. Commissioner as Advocate Mantula from the Investigation and Conflict Resolution. Chair, I was looking at the time and what then will be the way forward from us having traveled so far and looking at the questions and the issues that we have been engaged on.
Way forward is coming, so you can hold it.
Yes, Chair, but
no. If you are going to deal with way forward, you'll wait.
No, I'm not, Chair. I'm not dealing with it. I'm dealing with the context of what we have been engaging since 10 o'clock now.
Okay, but you will come in to answer questions or clarify.
Correctly, Chair.
Okay, which one are you answering?
The one that I wanted to clarify, Chair, as a follow-up of what you have asked to say, has been one of the person who was interviewed by the SSA, that what you are raising here, it is correct that what processes should have been taken. I don't think that the issues that were raised with them were correct, considering that there was no confidentiality, there was no national security threat, in the sense of that it was communication on the Section 22 committee, legal opinion of this committee, in terms of how they view what we call procedure and substance, substantive issues and procedural issues. And Chair, I am raising all these things because I've sent this committee since October until now, 7 emails as a concerned commissioner. It was never answered on the governance and the Section 22 issues. And when you look at this country, if you talk of the freedom of religion or the rights of religion, post 1994, the Commission's mandate is not only religion, it's culture and language. Hence, Honorable Van Veek, when he was asking about the Khoisan issues, they are not only Khoisan issues. You have healers, you have Rastafarians, you have many communities that have been left out. Now, if the oversight and the foresight and undersight of this committee is to assist this commission and to bring issues to the nation, and we don't address sensitive issues. The last point that I wanted to raise, Chair, you were asking about complaints. And I can assure you that there are very few if you have to look at abuse or issues around abuse of belief system since our term, since we have come in last year. Again, is the country taking issues of culture, religion seriously if this commission was appointed 6 months later? So you ask yourself sometimes that, are we really aware of the dynamics of culture, religion, and language as the heart and the soul of this country? The issues of budget being the least funded commission since its inception 21 years later. Are we a passerby at Chapter 9, or are we just an additional? And those emails, Chair, that I've sent to your committee, they were highlighting some of the issues that we've been raising now. And I ask myself, including the Office of the Speaker, maybe am I a Rastafarian that you don't have to answer to me? Or maybe I'm not politically connected? Because one of the issues that was raised here, which I find it very strange, church and state relation are very sensitive. State, it is for all. Religion, spirituality is personal sometimes. The issues of the legal opinion of the committee that we were engaging in our last plenary, we have find it very strange. It says the Section 22 are lawful, but let's wait for the court. The second aspect for us, Chair, is that it is important for us to constantly look at the solutions in terms of what worked previously in the 2019 post the report when it was attached, and 2026 where to. Because for me is that we have the NCC resolution of 2024. And those NCC, the National Consultative Conference, there was never issues around regulations, I mean issues of commercialization report and state regulation of vis-a-vis self-regulation. We have to be honest, if we have looked at the NCC report of 2024, because that's your basis. The last point, community councils, Chair. This commission was set up to...
I do want you to focus on what you're trying to do.
Yeah.
So I don't want you to raise all the issues.
I'm raising because of time, Chair, and it is based on the issues that I've said, that it took more than 6 months for this committee to can engage with us as the commissioners. And that's where there's repetition on all these things that have been raised. Even all the churches that have been appearing before this committee, they've been raising historical issues that have affected this commission. Even when the new commissioners came, they have to deal with the same issues. So as I was saying, the last point, rather than focusing on self-regulation or state regulation, and as the committee members, I think it is important for us to engage, not only for today, we have to engage beyond. And that's where our act, the CRL Act, speaks about the first term when you come into office, you need to have an NCC to receive your mandate and to engage. And hence I am lamenting that if we have to reach out and to be known, and we are not funded, we don't have provincial offices, you ask yourself, well, how do we impact our own communities? And hence I say to you, Chair, it is very important about issues that have been raised there, but the issue of working on a national security issues is something that is very sensitive, and we have to be mindful of that. Thank you, Chair.
Okay, I don't want us to move all over the issues, but let me be direct on your story. From probably sometime in October, November, there have been a number of issues that relate to the CRL that we've had to deal with. And a lot of them, we deal with them outside, and some of them present themselves onto us. So we've not had enough time even to deal with all these issues. If we had our own way, we would have had a lot of meetings with CRL long before, apart from these other problems of, how the communication has been. I'm aware of your communication. We will deal with that issue. So it's not about who you know or being a Rastafarian. So please take it out of your mind that that must be the reason. It's not. So you will actually get. I'm even surprised you say that there is no response. As far as I'm aware, there should have been a response. I'll check on that. But not an appointment set, because the other pressing issues that have been coming were the ones which were not only just coming to us, but coming to Parliament, going to the President, going to ministers, and so on. So there is no such a thing as Rastafarian. You would need to know somebody about before you can be attended to. But I'm aware of your letters. But let me come back, honourable members. We've allowed the discussion to go over insofar as the members wanted to clarify various issues. The core of the issues here for us, from the point of view of the committee, has been the complaint from a number of church groups about the way the CRL has gone about dealing with their mandate. In the first instance, you have a report that goes back to 2018 that was tabled to the portfolio committee, and then the subsequent portfolio committee of the resolution, which we have had the chairperson refer to. And of course, the issue from 2018 up to 2025, about 7 years, 7 years before there was any action. So the issue arises at that point. And when we looked back, in our case, the report that the committee, that the CRL was referring to, is a committee that belonged to the term that had lapsed and had not been activated. So the legal opinion that we had not much to do with whether the committee report had lapsed or not, although that is the case. The issue was trying to separate a number of matters. Section 22 committee is a legal mandate of the CRL. Whatever it's supposed to do, but Section 22 as a committee, that's the mandate. The question which was on the table for this committee was whether the committee, whether the CRL, in pursuing its Section 22 committee, is it doing what the mandate of the committee on the commission is, or is it already infringing on the right to religious practices and freedom of worship? And on that basis, they took the matter to court. Then there are a few other issues which they raised. Now, on that matter that went to court, the committee did not get cited and were not part of that. But the numbers of people who have been raising objections include those who went to court and those who did not go to court. We have since had a number of meetings, and some of them have tabled formally complaints, which they referred to the chairperson's conduct. And I did alert her that there is this issue that has actually arisen insofar as the committee is concerned. Now, so far as the conduct is concerned, a number of issues have been raised, and I see that Advocate Zulu says is responding to criticism. I'm not sure which ones, because we have not really tabled this to the committee. So assuming that it's the same issues that have been out there in the public. Now, in dealing with those issues, this committee has had to face a question of how do you then manage this matter? On the one side, we all are aware of the need to address the abuses that have been experienced by communities right across. in relation to apparent conduct of certain religious leaders. The question that seems to be arising and in your submission relates to a kind of code of ethical conduct across these different religious leaders. In this discussion, the question between the CRL and its Section 22 process and those who are objecting is whether the way you're going about it is the way that actually is supposed to deal with the issue. We have actually asked a number of them, are you opposed to a code of ethics? And I've not heard anyone who said no or said yes, they are opposed. Now, obviously, from where we sit, there's a degree of misunderstanding. From the point of view of where we sit, I think from where you sit, you're saying that there's trust deficit. The question of whether the legislation subsequent to that is the way to go or how to go about it, for us is a bridge further. But where we are, we're at a point where how do we deal with the fact that there's no disagreement about the need to stop the abuses? And the question is, are the way you are as CRL going about it in your Section 22 committee the way or not? And we can never judge on that except if we are able to get a situation where those who have a view for and those who have a view against are able to sit down and they can work out whether in fact there's an agreement or disagreement. We're not talking legislation yet, we're talking about code of ethical conduct. Now, if that is the case, this committee has been trying to find a way around this. And the point is, now, the point is why we have actually asked for the list of those religious leaders that agree with the CRL to say, let's sit down and hear what they've got to say. You have given us your sense of view. But where to this committee we sat down with the legal teams of Parliament and we said we've got a complaint and we have a complex matter. Would you guide us? And from their point of view, we have an option as the commission and the committee of trying to see whether there's a way of clearing the misunderstanding or mistrust so that we can separate the issues out to get to a point where whatever processes proceed, at least we have dealt with the resolution of the misunderstanding. Now, we can't tell from here whether it's possible or not possible to get this matter resolved. We are also not inclined to try and quantify whether it's just too few, they must be ignored, or the numbers that you are quoting are too many, they are agreeing and therefore must disregard anyone else. We wouldn't believe that's a correct way to do it. What we think would be important is to find a way to say the owners of this mandate in terms of the ethical conduct are those religious bodies. Can they sit here and address this committee to say, okay, there are areas where you are differing, but is there any way you can actually agree on an approach going forward? Now, we're taking the CRL issue out of the way, not so much to say that's not a process you should be involved in. Once the complaint has been brought to Parliament, Parliament has to find a way to deal with it. We therefore do disagree with you in the way you have put it, and I want to go back to your presentation because I've seen, when we keep asking, is this your document? What does this document mean? Because what we might misunderstand what you're saying, but maybe it would be important to get you to clarify so that we don't sit here with a kind of misunderstanding. I'm trying to get, can you get that presentation by Advocate Zulu back and go to slide 16? So that I don't want us to misunderstand each other as we sit here so that we know how we can go about it. Now, the list of issues that are raised, no, that's Ms. Kaluva's presentation, the other one, the subsequent, not the slides, no, it was the text, no, she was reading through the text. Let's go through the text, yeah. Honorable Van Zyl, I hope she comes back. There are issues that we need to deal with her. Sorry? Okay, okay. All right, so let's get the presentation. I need to go to slide 16. I don't want to misread the thing on my screen. Slide 16 in the text. Okay, I'll have to read it from my system here because it's going to be easier for me. Now,
So, Chair,
yes.
if my question hasn't been answered, are you still going to allow me to come back, or I should just make a follow-up or raise it?
Okay, I'll give you that space.
Okay.
All right. Now, this is the part that I'm interested in. It says no court has issued interdict preventing Section 22 from continuing its work. It says applications before court remain exactly that, applications. Until court determines otherwise, the Commission remains constitutionally obligated to continue fulfilling its mandate. Its Commission respects the authority of the judiciary fully and awaits the outcome of legal processes. At the same time, Parliament must also respect the principle of separation of powers by allowing the courts to determine matters properly before them. Now, you will explain to me what that means. From where I sit, it's like politely, guys, pass off, get out of the way. That's what it says. Now, you have a right to tell us that. We also have a right to disagree with you. And in this case, we actually feel that this might, if my interpretation is correct, might drive us to an impasse where you have a view, we have a view, we don't agree, and therefore that's it. That's what it sounds like to me. Now, let me get back to the reason why this point is important. You see, when you get a legal opinion, you can underline where it matters for you and what you think it makes a sense. So one point that's being put by the legal opinion, our legal opinion, is that Section 20 is CRL. We agree. It therefore says Section 22 can do whatever it's doing in terms of the mandate. You don't have to interfere with it. We agree. Except in this case, we're not so much wanting to stop the CRL process, but we have a response to give to people who have raised concerns in Parliament on a matter that the CRL is doing. And with this statement, we're saying we want to hear what everyone is saying. With this statement, we are hearing you saying, stay out. That's what it sounds like. Now, there isn't a way we can actually tussle over a TEF because our TEF is not Section 22 work. Our TEF is oversight over the committee. Our is also listening and managing issues where there are complaints. And actually, our TEF is dealing with the complaints about the CRL. That's our TEF. Now, to deal with this complaint, for us, it's more useful if we sit down and listen to everybody, then we can determine that, in fact, there's a case here for this investigation and this direction, or whether, in fact, there is a resolution that makes the complaints to move away. There are certain allegations which are here, which, from where I sit, if there was a different approach from yourselves as the CRL, you probably will not end up in the same direction that you might end up. And so it's all going to be up to this commission what you think needs to be happening. Then we will take the cue, because from where we sit, from the point of view of this commission, we want to listen to the rest of the other members who had agreed with this process. We want to see whether between those who have agreed and those who disagreed, where do they agree and where do they disagree? Not as told by the CRL, but as told by them. That's what we want to know. And for that to happen, that's why we've been asking for the list. Who are these particular leaders that you've been dealing with? Now, it would not be fair for a government or parliamentary process to actually have as part of its modus operandi a determination to divide a constituency. Our approach would be to try and see if we can get everyone to find each other. The accusation of government, state regulating religion, and the issues of the allegations of the involvement of state security is creating an environment that's going to make it difficult for the CRL process of Section 22 to continue the way it is doing, because every day we see there may be others which are cropped, Madam Chairperson. There are others which are not cropped. There's a lot of mobilization that's going on out there. The CRL Commission is going out to having meetings and posting them, and we can see, and the other church groups who are opposed, they're also going around mobilizing and putting the issues up. In fact, excuse me, in fact, at a certain point, some of them were saying what Mr. Bateman is saying. They think that there's a party political agenda driving this thing. There isn't. There's no party political agenda in this thing. We must just solve this problem. That's it. And as far as I'm concerned, that's why I was saying to Mr. Honorable Bateman, we're not going to allow the politicization of this issue here, because the issue is a bit bigger than just party politicking. The issue is about CRL. You were tasked to go and deal with issues of abuses. You started a process. Are you aware there are people who are unhappy? Are you aware that this issue can be mediated differently, instead of actually saying CRL process allows us to proceed, we can proceed, and Parliament must just stay on the side and not and allow the issues to be dealt with. Those that are in court must stay in court, and that kind of thing. I'm not sure whether we can get anyone to remove these issues from the court roll, but I do think that somewhere that the religious leaders can agree on something before we even get to this point. And I'm not saying we want to get involved in the issue of court. I'm not interested in the issue of the court. In any case, whether or not the court rules in favor of this or the other group is not something that this committee can deal with. So I put that aside. My issue from where we sit as a committee is we're not going to leave a situation where there's ongoing unhappiness that is expressed in public and in Parliament to the Speaker, to the President, and not find a way to resolve it when simply because we can't interfere with the Section 22 process. We're not interfering. You can continue with whatever your processes are. It's just that if that process keeps complicating this complaint, it doesn't help you. It doesn't help you. It's not for us to say, stop this, continue that, but we're saying if we do not actually get the space to pull this issue together, I don't think you're going to achieve what you want to do. And already this committee is not going to be happy getting a report that has actually left people behind. You're saying you're not sidelining them, but if at the end we're not able to get this issue resolved, that would be almost like some of the people who have been sidelined. So that issue would have been with us anyway before even your report comes. So we were then looking at this from the point of view of the committee, meet all of these teams, go through this discussion, not a CRL process. It's a parliamentary process where we sit here and listen to them and see whether they together can say, okay, up to here we agree. let's separate these issues. This is where you agree, this way you disagree. Then let's that would have been the reason why we wanted to go through this this discussion with yourselves. Now, I'm going to ask you to make your comments on the matter, but I want you to note that there is something unusual about your relationship with the state security. It's a normal thing within government, but once people start complaining and create an insinuation that there's something sinister going on, there's an underhand manipulation of people and threatening and intimidation followed by state security, it raises, and I saw that on the Professor of I want to reject that, and in a situation like this, we should actually be even thinking that there's a political motive to drive this process, but there isn't. And I'm saying this because I'm part of the leadership of a party that, the Honorable Bateman was talking about, and I know that there isn't. What we do have is that there's a very robust engagement on a matter that would be a cause of tension anywhere in the world, whether it stays. It's an age-old kind of conflict, tension about state and religion. Certainly things have to be done, but when there are lots of people who are objecting and are complaining about a matter, and we don't find a mechanism to resolve that, that is really where we are. That's what this purpose of this committee would be. So I want to hold it at that for now, and then say, I'm going to ask you to comment, but let me get the members to comment so we can get the last responses on the matter. All right. Honorable Mtolo.
Chair, I would like us to go back to our engagement last time with the CRL Commission. A concern was raised with the legal bill. We even requested actually all details because it is not thanks to us as this portfolio committee seeing a commission having a lot of cases in court, because in the first place, it is money. This is public purse, causes unnecessary, concerns, from the stakeholders, various stakeholders, So, but my question, Chair, is I raised the issue of vetting. Okay. Came up with an issue of information is classified. I didn't know that actually CRL actually deals with classified information. So because before it deals with classified information, that person must be security vetted, that person actually must be security cleared before you handle such information. So, and then I would like to know actually if they are, because there are people actually who are actually legally vetted or security cleared to deal with such information. Because if they are not actually allowed in terms of the law to deal with classified information, if they are not security vetted or cleared to deal with such. Thank you, Chair.
Ngosi.
Thank you, Chair. Mine is a minor one, but I heard that when the presentation was made, that the Commission affirms that calling cannot be regulated. I think about a week or so ago, Mam Kalu, there was quite a bit of anger where I think the statement, I don't know if you misquoted or what, where you said nobody can come and say he gets for lack of a better term, he converses with God or something like that. Because I think we are saying the people who misuse it, like we said earlier, that people say, but now I was just not understanding because we have, for centuries we've had intercessors who communicate, but maybe then it was misconstrued or misinterpreted. But I mean, this bishop was talking about earlier, he said, you know, that it took a very, very strong exception that, I mean, now this is outside of all that is being done, the good work is being done. Is how the chairperson say and tell me that there's no person there who's got God whispering into his ear. It's a comment, but I think it does call for a comment, Mr. Chair, because especially of this affirmation, which was put on the table by the advocate Zulu. Thank you, Chair.
Thank you. Yes.
Thanks, Honourable Chair. Just two matters I'd like to raise. Firstly, I made the point earlier that the inclusion of charismatic and Pentecostal churches as a priority domestic terrorism and national security concern in the recently published National Security Assessment Report, National Security Strategy 2024-2028, seemed to me to be prejudiced and unsubstantiated. In response, the chair stated that I'm using my own words now, but we can check that I'm getting it right, that it's not your area of jurisdiction over what's contained in the National Security Strategy, fair enough. But I do want to draw attention to this, that the National Security Strategy formed its assessment based on the CRL's information. In the assessment is that the CRL in 2017 confirmed allegations of the mushrooming of charismatic churches, commercializing religion, and so on and so forth. And in a sense, their assessment is based on the assessment that informed by the CRL. So my concern is that the organization, which is meant to be protecting religious freedoms and is in actual fact now contributing to them being targeted and named as a domestic terrorism threat, a security threat. And that seems to me to be an undermining of the mandate. I just like to highlight that point, and perhaps there's at least, if not a jurisdictional responsibility, there's at least a moral responsibility to set the record straight with some evidence-based research. And then secondly, Chair, this is actually that is serious, but this is even more serious. Can we please check the transcript of this meeting? But it's my understanding that the chair said that the Cheryl Zondi Foundation did not receive money from the lottery. But on the 6th of March 2019, the chair of the National Lottery stated that it had contributed to the Cheryl Zondi Foundation. And in February of that year, 2019, a letter was sent by Nadine Badenhorst of 4SA inviting religious leaders to a meeting at Rhema with the chair of the CRL. And in the letter, she quotes the chair of the CRL as saying that the meeting was largely funded by the Cheryl Zondi Foundation, of which she is the chair. I hesitate to say this, but I am led to suspect that the chair of the CRL may have lied to Parliament in this committee meeting. And I would like to ask that this is checked and the committee assess that, whether or not that is true. Whether or not that is true.
Okay, let me try and get us towards rounding up. Comments? Respond on the outstanding questions?
Let me start right at the end. The issue of whether Cheryl Zondi Foundation was funded by the National Lotteries Commission is very easy to deal with that. The National Lotteries Commission has issued a press statement. After what they said in Parliament, we wrote to them and they issued a press statement saying the Cheryl Zondi Foundation was never funded by the National Lotteries Commission. And that is a statement that we can find and send to Sherin. No lies there. I think it's all out there in the open. And we can do that by tomorrow when we get back to the office. We have it somewhere on our computers, and that can be verified with the National Lotteries Commission. We don't need to do any science there. the issue of Honorable Ndolo cases in court, we are not in control of people taking us to court. We're just as worried as you are about the matters being taken to court. Unfortunately, Honorable Nkosi, the clips that we wanted to play with definitely addressing that. What we'll have to do is to send the clips to Sharon to send it to you. But what we'll also be doing is to put those clips on our social media platforms, because the clip says everything I said there in court on that day and what I was referring to. Once they crop the video, then they leave out the fact that God said you must sleep with me, God said you must give me my money, God said this. And it's not about genuine people who say they've heard from God. But I've always said God would never say, sleep with that girl, eat grass. And it clearly outlines that. It's unfortunate that we couldn't get it to work, but we'll have to send it to Sharon to distribute, and we can then send it to the people who are feeling uncomfortable. We'll do that by tonight. Yes. The 27 report does not talk about charismatic churches and Pentecostal churches.
Sorry, was 27?
2017 report that the National Security Report, no, the National Security Strategy report. They say it's based on the CRL 2017 report. We have, I think, given a soft copy to Sharon. You can read it from cover to cover and check if there's any reference in there to a security risk by charismatic and Pentecostal churches. As I said, I'll repeat, we're not in the business of security risks, but we're definitely in the business of protection of congregants. But you can check the report. And if you find that that report somewhere refers to security risk from charismatic churches, then the committee must do what the committee needs to do. But I can assure you, we've never seen charismatic churches as being a security risk. As I said, those are the people we've leaned on. Those are the people we have bounced ideas with. I said Pastor Macaulay, who was the president of the International Federation of Charismatic Churches, has been with us for many years. So we wouldn't have been attacking charismatic churches with Pastor Ray Macaulay in the house. It wouldn't be wise. It's not something that we do unless there's something wrong with us as the CRL Commission, because the report, it's not a Togomkwanas Kaluva report. It's a report of the CRL Commission that was written by the CRL Commission. I wouldn't have been able to write that report even if I wanted to. It was written by the CRL, owned by the CRL. So I'm not sure at what time do you then say we're definitely attacking charismatic churches and identifying them as a risk. We are identifying certain churches who had become a risk to congregants because they were treating people badly. Some of them are still treating people badly. But it's not about the report. The report is a public document. You can check it. If they read the report and drew their own conclusions as security people, it's not our problem. And as I said, Honorable Mtolo, we will send you our press statement on the allegations from Kulu, but our point of departure is that it's the SSA that must respond to him. We don't know what happened between him and the agent from SSA. We were not there. The letter that we wrote to them will be made available this afternoon. We wrote to SSA. It's not talking about investigate churches. It's not talking about investigate Prof. Kulu. I don't know where it comes with that, and I'm not responsible for his utterances, seriously. We'll give you all the information and you can then make up your mind from that. But is there anything?
Yeah. There are a few things which there was the issue of the vetting.
Yes.
I still wanted to come back to the question of your view about Parliament staying on their lane.
This was
Respect the separation of issues.
yeah.
Which one are you going to deal with the vetting?
Yes, Chair.
Yeah, and the vetting.
We do have some people cleared, Chair.
Just say that again.
We do have some people cleared who are dealing with security issues within the organization. Who are vetted and cleared. So
when you say you do have, it's not all the commissioners, it's not all the staff.
no, it's not all. So commissioners, when they are appointed, they are vetted. But I think what the honorable member was asking is about the clearance of dealing with confidential issues from staff members. We do have two who are dealing with security issues who were vetted and cleared by the security, by the state security. Our interest is that all staff members should go through the same process, but so far, the ones who are cleared and dealing with issues of security, those two members that we've mentioned are cleared and they can be accommodated to state security meetings.
Advocate.
Thank you, Honorable Chairperson. Perhaps the statement on slide 16 was incorrectly drafted. However, the CRL would never tell Parliament to not listen to its people. What was really meant by that statement is that the similar complaints that have been placed before you are also the same complaints that have been placed before the courts. So we thought it would be more prudent that before you answer to the people with regards to the complaints they've given to you, that we all just simply wait for the outcomes from the court. So
It's the same thing, eh?
No, we're not telling you to mind your business.
Look, it's the same thing. We're not cited in court. So what are we saying? What are you saying to the committee? We're not cited.
But the complaints, the ones that are before the court, are similar to those that are before you.
So what must we do?
So initially, what the connotative meaning of that statement was that because it's a pending matter, how can you make pronouncements on something that is still before the court?
So we must shut up and stay on our
No.
lane. You see, the reason why before you raise the report, I wanted to know, because I wanted this commission to say that's our statement. And you did confirm that's how you're looking at matters. I asked the chair, I stopped you and I asked the chairperson. And the reason why I'm raising that is because you are then saying one of two things. We as this committee must leave all these issues that are being raised. Alternatively, you are not going to cooperate with whatever we do. That's basically what it comes to. And we ask you the question, is this the commission's report? And we asked why. And I stopped Mrs. Mkhwana and said, no, wait. What is this statement? You sent this thing to us. We read this thing. So we understand there's an attitude in the statement. And we can see the statement is saying to us, that matter is in court, stay in parliament. Effectively, that's what it says. You want to make it simple. This thing is in court, stay in parliament. And we're saying, okay, we understand you. You are therefore saying we can't continue with this matter. And it takes us back. You remember I asked the chairperson, in the one meeting, I asked chairperson, please talk to us. And she said, no, we're not talking. Then I asked the question today. Last time you said you're not talking. Are you now able to talk? Then she said, no, we can talk. Now your statement subsequently says, no. The matter is in parliament, is in court. Parliament must clear. Now, we make the laws. We understand the issue of separation. We also got our own role separate to the court. We can deal with the matter that is in court and deal with a matter that's in parliament. And there's no law that says parliament must stop dealing with a matter that is in court, except if parliament was going to discuss the details of the matters that are tabled in court. But we sit here and talk about other issues on the same matter that have got to do with us and not to do with the court. And we also sit here and there are things which we'll deal with, which we don't believe they will actually even surface in court because they've got nothing to do with court, they've got to do with us. And so we know the separating. But to have a lecture of 17 slides telling us that is another problem. And we're raising that because we see we've got a lot of noise coming to parliament. The speaker then had to make a statement to say, please, portfolio committee, go and deal with this matter. Now we're dealing with this matter. And the CRL then says, no, guys, stay in your lane. You understand? So that's why I wanted to clarify. And I wasn't asking you to clarify. I was asking the chairperson to clarify, not you. Not that you are wrong to clarify, but I'm saying, because at the end, this is a statement of the commission. Now, our next step going forward is going to start doing in this matter, which you're saying we must not deal with. And we know we're not going to make this matter as a court. We're not going to sit as a parallel court. But we've got people who are in conflict here. It's our role, it's our duty to actually. When Honorable Mtolo is raising the question of the budget, he's not saying you took yourself to court. It doesn't, not saying that. He's saying if there was a way of approaching this matter that he should not have landed in court, we would have used that. That's what we're saying. Now, we can't be told, no, we didn't take ourselves to court. What are you saying? I mean, you mean we don't know who took the matter to court? We do. But we're saying there's a lot of cost involved. There's a budget challenge. We've been talking about the budget. The question of the budget and the cost of the human resources at more than 60% is a matter that took a long time for the commission to deal with. Now, we're saying there are issues which are avoidable, and this is one of them. And the matter does not need to end up in court if people could have understood each other. Is there a role we can play? Now there's a legal opinion. 17 slides. It's basically telling you are going to go ahead with Section 22 process. You have a mandate for it. You have a commission. You have a legal mandate to deal with the matter, and therefore no one else can stop you because the parliamentary legal opinion told you so, which is us, and they did tell us, okay? And that's not what we're trying to do. And at the end, we're simply saying, for this thing to be dealt with, we need to find a way to reduce this mistrust and misunderstanding, and that's what we're trying to do. But your legal opinion, it's not coming for the first time, it's coming for the second time, because the one time when we raised this issue, you are not prepared to go into the discussion, even as to guide. This meeting partly was even delayed because of that. We're not sure. How do we actually get you into this meeting? Because you actually said you're not going to speak. Understand? And then we had to actually say to speaker, maybe call the commission. Maybe we'll have a different approach. And of course, that meeting didn't happen. We explained why it couldn't happen and so on. But it's not because we've not been trying to deal with this issue to try and resolve it. And it may not be our responsibility to resolve issues where the CRL Commission is seeing that there's no problem. But it is our responsibility to respond to those who are complaining. It is also our responsibility to resolve the issues where we think that before we have to go into a legalistic process, we could have actually got people to discuss. Now, legalistic process for us, I'll share the legal opinion with you. Our approach was, if we have to take this matter forward, the law explains how we go about it. Now, to get that process, for us, this committee wants us to clear the issues, because we think that there's just a lot of misunderstanding on issues that people can find each other. And that's what we're trying to do. But it has to do with attitude as well. You know, we can't have a situation where it looks like, well, listen, so hlangana phambili. You understand? That attitude is a problem for us. Now, okay, I do understand that attitude. You know, that's what it says. You understand? And I'm saying your statement is giving us a difficulty from that point of view. So how do you see, you have now given us all your stories. What is your, you've heard what we want to do. Give us your view. And that's why I don't want a thing, you know, advocates, don't get the way. I want the commission here. I want the commission, because you have given the legal this thing. So the way it's written, you say now it was not properly written. I wouldn't have expected this commission to allow the statement like that to come here, and it's their statement. I would have expected that. But nevertheless, I'm coming back here because we now must close the matter. What are you saying?
Honorable Chair, there's a challenge. You rightfully say you'd like to mediate the situation for the 2, 3, 4 parties to find one another in terms of the CRL and the other 3 people who are in court. One of the issues in those papers is that the South African church defenders have said they want no mediation in their court papers. And our legal people have said trying to mediate this matter would then be in violation of what they put in their papers, which I think we can send you because you were not cited. So probably
I do have the copies. I do have the copies.
Oh, okay,
I have read it as well.
Okay. We are confined by what they put in those papers, that there should be no mediation. I know some of the people who are attached to Section 22 have asked whether they can mediate us out of this. And when their legal people looked at the papers, they said, unfortunately, the door is closed by the South African church defenders. Hence, our legal advice was that at this stage, don't even get there until we workshop you to say, this you can say, that you can't say. It will affect this part in the legal papers. But the CRL, and I'm sure the commissioners will agree with me, with the CEO, who have always been open to talking. And as I said, even a week or 2 ago, South African church defenders was invited to come and explain themselves to the Section 22 committee. Forza was there. All the people who are shouting out there, it's not like we're ignoring people. There are legal parameters. When you get legal papers that say there'll be no mediation in these issues that are in front of the court, it cuts our hands and our feet.
We're going to have to get towards the end of the discussion. I'm not sure which of these groups that you'd met are already in court that you're already talking to.
The South African church defenders.
To them.
The Section 22 committee spoke to them. We cannot talk to them because they don't want mediation. The other people who are not in court, who have said they don't want any mediation, even if they're in court, if they have not said, they will not allow mediation in terms of this case. Those that say they still want to talk, we can talk. That's the Muslim Association of Lawyers. And the other one, but those that are in court that do not have that clause, I don't know what to call it, but the clause that says no mediation in this matter. It's the South African Church Defenders. Anybody else, the CRL Commission can meet with.
Well, I will not go into that because I don't know the difference between meeting with the CRL Commission and meeting with the CRL staff or meeting with the CRL subcommittee or Section 22 committee, what difference it makes. The point at the end is that some of the people that have been to court have met with one form or another of the CRL outfit, whatever that is. I don't want to get into that. I would just want to say one thing. From our point of view, we have an untenable situation. We have a complaint which we have to pursue. We have a situation which we think is avoidable, and we've got an approach that we think will assist the process. Anyone who would like to assist in this process will talk to them. Now, if insofar as you as a commission are concerned, you have the view that you have, we will wait to see what your approach is. I'll get back to this clause, to this statement of saying the parliament must respect what is in court. This parliament is not in court. This parliament is going to deal with issues that are raised with the parliament. This parliament does not see that this relationship that's being built with the Section 22 process and the various leaders is all as healthy as we would like to see it. Part of the problem is that it doesn't matter how far you go with your process. For this process to come back here and we wait for that opportunity, when in fact we are aware that there are challenges now, would be responsible on our side. So we are going to pursue the process. All we don't want to indicate to you is that the language that is a little unfortunate, especially if I get back to your last point, because when we're going to take a stance that is combative, it becomes a bit tricky as to how we're going to manage this whole thing. So let's wait for your processes with the court. We'll leave that to that process. From where I sit, even with all of what we're saying, we may not be able to deal with the issue that is in court, but that does not stop us from actually engaging all the people that are involved. And I'm not sure from where you sit, you would like to see this committee go. But if we must go by the fact that you say we must listen, we must respect the separation of powers, I think you've got a misunderstanding on us, and we're not going to actually follow that. But if you've got another proposal, we'll wait and hear about what that other proposal is. From where we sit, we are going to have to deal with all the groups that are involved, because we believe that these issues are a matter of approach. A different approach would actually land us with a different outcome. The issue of what ultimately gets resolved in court, you see, between us as we sit here, there's one thing that we are agreeing about, and whether we are there or not, it's difficult. So everybody says, no, nobody wants the state to regulate religion. Nobody disagrees that, okay? But is that what your process is doing or not? Now, we might not be able to resolve that issue if that matter is going to be dealt with in court, unless there's another way. We might not be able to resolve that issue. But our point of view is that there's a lot that can be achieved even before you get to the point of disagreement. And that's what we think we must not be irresponsible not to try and pursue and pursue. That's really where we would like to leave it. Whether we understand each other, I'm not sure at this point, but where we are as a committee, we think that there are a few fundamental areas of agreement that are worth dealing with. The one is the issue of the other abuses in churches. And by the way, that research that we're talking about, we do want to see it, because the other complaint that we are targeting particular groups, when in fact the prevalence of abuse is more or less the same across the different churches. We can't answer that question. So the question of abuse having to be dealt with, we all agree. There's no problem about that. The question of whether in the course of this, an understanding of a code of ethical conduct needs to be developed, and we have not had any disagreement on that. So where is the fight? So that's what we want to deal with from where we sit as a committee, and then we can move the issue from there. But having said so, we do want to say, having raised this issue, we're not sure we do understand exactly where the commission stands when we look at some of these things. You have explained it, so we leave it at that. But from where we sit, we don't agree that on this matter we must stay away. That's what we're saying. Let's get one comment, last comment, and then we're going to close the issue. Yes?
No, thank you, Chair. Chair, I fully agree with you that we might have interpreted the separation of powers wrongly. The issue of cooperative engagement with the committee is very key as this commission. We do report to this committee. Our annual report, even the budget vote tomorrow, will expect this committee to be on our side. So I think we have to work together, Chair, and I fully agree with you. We might have averted all these court processes if we could have engaged initially. And as you said, there have been different national marches. And I think it is a matter of cooperative governance. I don't think you are mistakenly being cooperative governance for no reason. The interconnectedness of us and your committee, Chair, and I will support that. Probably as a commission, if we are having a special plenary next week, we have to reboot and withdraw and come back and say, how do you want to work with this committee moving forward? So for me, I will urge that we need to work together, Chair. The same with the communities of practice, we need to work with them. We cannot talk to one another with just through media and through papers. I think there is a need for that concept of Ubuntu, as it is the mandate of this current commission to work on fostering tolerance and engaging. So I will pause there, Chair, to say, indeed, we have to find a way. We cannot say government must stay away. They have to play oversight, like I said earlier, and even foresight. Thank you, Chair.
Thanks very much, Chair. This is what the chairperson of the National Lotteries Commission, Prof. Alfred Nubufanda, said, transcript, I'm sure you know the story of Cheryl Zondi, who was abused by the pastor. We contributed money through another organization. Her foundation linked up with that organization in order to move around South Africa, telling the status of women and how they should conduct themselves and refuse or refute the abuse of women. That was the project that we are proud of. And in the media statement to which you refer, they clarified that there was a grant of 1.5 million that was awarded to Izimvu 447 NPC, not directly to the Cheryl Zondi Foundation, but that NPC had then partnered with the Cheryl Zondi Foundation for awareness campaigns. Now, if you think about the words of the chair, speaking about how proud they were about how they'd funded the Cheryl Zondi Foundation, you think about the email that was sent by the by Badenhorst of 4SA to those religious leaders, inviting them to the meeting at your request, and also referring to the fact that it had been funded by the Cheryl Zondi Foundation. To me, it's amplifying my concerns that you're misleading this committee by not acknowledging the funding that came from the lottery to indirectly to the Cheryl Zondi Foundation, and not being transparent with us about that. Thank you, Chair. I submit this to you.
Thank you. I think we don't need any more response to the matter. You have raised the question a few times, and you are going to submit that information. The committee will have to follow the matter up and investigate whether in fact there has been any misleading of Parliament on that matter. So we will deal with that. So let's just receive the information at that point. Okay. This one's sorry. Oh, I see. Honorable Taibosh, you raised your hand. Sorry, I missed it. Is it Taibosh? Oh, I see. Oh, I see. Now, okay, there's a misunderstanding here. Look, we want to round up this matter. We'll still get back to Honorable Francine van Wyk. If there are any other comments, so we close this matter at this point. No problem. Let's leave it. All right. Now we're going to come back to your answer. You will still come back to your answer, Honorable van Wyk. Wait a bit for that. We'll come back. I just want to close the issue that relates to the Section 22 item. So I'll come back to you. Let me then say, now, I don't know where there is. Oh, Glenn Taibosh, is your hand up again?
Yes, Chair. Chair,
Yes,
there was just something that I keep pondering on. You know, I've been largely covered because I think our team was in top form today. But I've been largely covered. But what bothers me here, Chair, is when the chairperson starts bending about numbers, and you know, just that the CRL it's been supported by over 40 million. Now I look at the amount of people in South Africa, you know, and my question is, can she actually back up that 40 million people that are members of the various churches? Look, I know that the ZCC and I know the Shembe Church, they have a lot of members. But us as a political party, we were approached by some churches who said that they have 10 million members. And, you know, we welcomed them. But when it was time to deliver, there wasn't 3,000 members. So I'm just worried, and I'm asking, my question is, can the chairperson actually back up those numbers of over 40 million? I thank you, Chair.
All right, all right. Your question is valid. I don't like your example, but yeah, your example is problematic, right? Yeah. Now, I don't want to say that you were misled by members of the church about numbers. Sorry, yeah, no. And your party process, we don't know how scientific it was. So let's just focus on the information that we want to request from the.
That's why the question, Chair. People can say anything.
All right, that's fine. That's why I'm saying that I want the example to be put out of the equation. Let's deal with the core of the issue. That's fine. So that's fine. Look, let me then say, I would like us to close the matter. From where we sit as the committee, there's a bit of information that I want to request from you. The issue of the budget, we hope that you will get that. You have already forwarded. Thank you. That's fine. Then the second one is the list. The list. We said 6 o'clock. Don't worry. It's not 6 o'clock yet.
Sorry for that, Chair. I was saying, if possible, Chair, we are requesting that perhaps we send tomorrow. From here, we supposed to rush to the airport to go back to Johannesburg. So I can say 6 o'clock we'll still be flying. And obviously we'll land there after 8. So I'm worried that maybe we may not be able to forward the database tonight because we must get it from the office, not from our houses, Chair.
Now, look, I'm not going to accept that. It's not like you're operating from Bataza, you know, where you're far from everywhere. The reality is that we're all working online. And we're not going to allow that because, you see, we've asked for this for a long time. And I'm not sure whether in fact it's because it was not available or it's because somebody didn't want us to get it.
Now, it wasn't
What I need is a list now. What I'm gonna ask for, the rest, we can give you time for it. But the list you must get. So let's not debate the time because it's somewhere online, that thing. So that's not my problem. So the issue of the list, let's put it aside. We are gonna get the list because it's been a long time and I've been actually checking every week what is happening and I don't understand why. So I don't believe that we must then say we must wait for a long. The other day it was no, we're working on it. And I asked what was the response. So let's not argue. Let's just agree that we're gonna get that list. But what I'm gonna give you time for are the following. The first one is that what the team has asked, what the committee has asked for, are the groups of the religious leaders. Which groups are you working with, and which groups are were in support of the Section 22 process? Okay, if it's gonna mean you do that tomorrow or the day after, that's fine. But let's get that list so that this committee has got a sense. Secondly, which groups were against? Which groups were against? And then which ones you think were against and later changed? Okay, we need that information. That comes in the form of a report now. It doesn't come in terms of a list of contacts, which is the same, is not the same as what we were talking about. So that's the first issue that we're going to request from you. Then the second information that you're requesting, the question of the state security. The members have requested that we must get the communication with the state security. Let's get that. Because we need to clear this issue that, we're now using the, state security to harass the churches. It's not a healthy one to allow to continue without being corrected. Let's deal with that. So give us that information so we can at least close that chapter. The third one is the issue on Professor Kulu. You're going to give us information. We ask for the allegations against Professor Kulu. We ask for the correspondence, your letters to Professor Kulu. We ask for the vote of no confidence and any document that relate to that. Give us that package so that we don't only have what Professor Kulu said. Let's hear from your side what has been happening. So we need that. Then this committee will then look at all of that together. Because a number of the things that to do with Professor Kulu go to the social media, we pick them from there. So that's why the statement you saw yesterday, with same time with us, we also saw it yesterday. So let's get your side now so that you can deal with it. Then this research that you were talking about on abuse, let's get that research. We've not got a report. We've all been talking about that. You seem a bit puzzled. Well, there was the issue of the research that was done from, I think from the NCC process. You spoke about some research that was related to, sorry? No. It's survey, not a report. It's not research. What? Let's. Okay. All right. Let's just clarify it. Let's clarify that. Let's come back just because. Let's clarify that.
Sure. Thank you, Honourable Chair. Yes, what I was referring to in my opening remarks is the survey on the status and experience of the rights and responsibilities to religious freedom within the faith communities of South Africa. Multi-year, involved thousands of organizations, significant cost, but it's been withheld. The CRL then informed us that they were wanting to do it in different languages, different formats. But to your point, there's no reason why we can't have the results of what is available to date. Thanks, Chair.
Okay, do you understand each other on that one, Chairperson?
I think I responded to the honorable member about the report, that the report it went to plenary and plenary took a decision that the report needs strengthening by making sure that people who don't have access to online because it was done online and excluded a lot of people, and that we need to have hard copies to take to communities out there, and then get the balance between those that can be surveyed online and those that need to do it by hand.
Just, so where is that process?
The translations have happened, and the only thing that is left is that when staff members and commissioners are going to communities, they then give them those hard copies to fill in, which they'll then come back with. We have also been looking at possibilities of whether Kwashembe can't help distribute the papers and ZCC, etc.
Okay, so the originals, they say there was an original survey. Was that word of mouth? Was it something in writing?
It was something in writing that was found to have a lot of gaps in it.
Can we share it, even with gaps? Because you don't have the latest. Is it something that one was in writing, and you said it had gaps? You don't have the latest now, but can we share that one? That was supposed to be strengthened, because you don't have anything right now which is latest.
Chairperson, through, if I can assist the committee, the report is not ready because we have not adopted it formally.
So the first one?
Yes, yes.
So it was never adopted?
We said that we needed to strengthen it, and the process of strengthening it then what needs to happen in order for us to say this report or subject it further to plenary and then adopt it.
Do you have a timeline for it?
I think, Chairperson, we can forward that. I think I don't want to speak out of context in terms of the unit.
Still gonna take it to plenary, then you can. So when is that likely to be?
I think in the next quarter, 3 months.
All right, let's leave it. Let's agree that you'll finish that issue up. Once you've concluded it, you'll share the report with us. Now, the issue I was interested in was on the issue of the survey around the abuses. Now, you don't have any sense of research around the issues of abuse across the different. That's the part I was interested in, because so the first question I was asking was, when you were saying that there's a problem with the non-mainstream churches, so I wanted to get that. What is the conclusion based on? Is there research on that?
Chairperson, the point that we are making is the report or the survey as it stood is not at a quality or at a level of inclusiveness that is required by our quality assessments in terms of ensuring that we can put that report out to the public. So it needs a lot of work. I think it's not ready, and we want to ensure that it is comprehensive and it covers all sectors of our community.
Okay, let me just check this. This commercialization of religion and abuse of people's belief system, what is the state investigative study into? Is that the same thing?
No.
So which one is this? Or do we have this one as a report?
Yes, we have that report.
The
Sharon
report that was given to the previous committee.
Oh, that one.
Yeah.
Oh, okay. No. That's a bit confusing. Let's leave that issue. So let's come back to your point now. Your process is going to take a couple of months. We're saying give us that information.
Correct.
I'm just saying. I'm saying each time you make a distinction between mainstream and non-mainstream churches, it creates a controversy, because it creates an impression that you've got sound information on which you are basing the allegation or the conclusion. And that's why I keep wanting to get to the what makes us make that conclusion. Yes, that's why. Now I hope that this report that comes might be able to answer those questions as well. But I'm saying you be aware, particularly as chairperson, if you make those statements, we get commentary on the basis of that. And when we sit and listen, we think that there are statements that need to be carefully worded, otherwise they get misinterpreted. And in this case, I think you are getting yourself misinterpreted, because from what I'm listening to you, what you're trying to explain and what it sounds like two different things. And I don't want to waste time on that. But each time you make a distinction in this group of churches and the other group of churches, and you say, okay, what information do you have about them? We don't. There's no information. It becomes a bit of a prejudice. So that's why I'm just making that comment about how you articulate. And I'm not going to censure you. I'm just simply saying, be aware that when we sit here and we listen, sometimes it doesn't sound quite like what you are actually trying to say. It sounds like something else. But let me leave that point, because at least the issue of the survey, you will get the information. Then the next issue, the shadows on the foundation issue, we're just going to have to investigate it and see where we are, because from what we're seeing, well, I've seen this report that they are reading. So I know I've seen the report that they are reading. So we now need to get back into the details of it. But the report that they are reading was actually sent to me already before you came in, Mr. Bateman. So we'll deal with that. Then you have clips that were sent. You wanted us to see. We have not seen. You will still send them for us to have a look at. But let me also say, in a way, those clips are from what you were saying. Some of them sounded like there were people intimidating or harassing people. What we didn't hear is whether, in fact, there's a case laid with the police of intimidation that either the commission or the individuals would have actually reported the matter to the police, because it's very difficult to deal with a matter unless we know that there's a case number there on this matter. If I say that this issue is an infringement on my rights, somebody needs to report it somewhere. So I would have hoped that there would be that. And in this case, we're saying those reports, we also need them. If there are case numbers associated with these clips, give them that as well. They give them to us as well. Okay. Now, they are not the only clips. We've got clips that were brought to us from the complainants with regard to some of the issues that they were alleging that you raised. We're holding those because they were played to the committee, but I'm saying that there's a lot of clips. We also share some of the clips when we see them, understand? So they're going to have to be a way of how we process all of those issues. At this point, let me just say, we'll need that information. Now, except for the one that you can wait for a month or two for, but I hope that you can actually share this within about a 10-day period so that we can give you space for it. Except for the 6 o'clock CO, the 6 o'clock, that one doesn't change, but the others will give about 10 days to give us that information. Now, once again, let me get back to this point that from where we sit, we're not going to be replacing the court, but we will deal with the same matters that have been tabled to us. As far as we are concerned, we're aware of what is in court. What we're dealing with here is our role on the matters. So we will continue. Now, we are saying that process might assist to resolve a lot more of the tensions that are here. But we will not then say we're going to stop you from proceeding with your issue. But be aware that as you do, it actually does complicate the space. If there was a way of getting these matters discussed in a manner that they are clearly separated, there might be narrowing of issues in terms of where you disagree and where not maybe yourself. Let me not count you as disagreeing, because I'm more interested in the other religious groups where there is disagreement among the religious leaders. That's what really we're interested in. Your process, we'll wait for your report, but so far as we're concerned, we want to deal with those religious leaders to the extent to which matters have been reported to Parliament. That's what we're going to be doing. So let's hold it at that. Then we're hoping that when we need your cooperation, we will get it, despite the fact that you are not so sure that we are on our lane there. So we will nevertheless, I don't know your legal team will guide you if they think that we're not on the right lane. They'll tell us that we are not going to come and be part of that. That's okay. So let's then close the issue with that. Can I just request the Honorable Van Wyk to raise the last issue? This issue is not specific to this matter, but it was triggered by the fact that Honorable Van Zyl raises a question on the representation or inclusivity of the process, insofar as she was understanding that whilst there are groups of churches, there are also language-based, categorization of churches, and that's why she raised the issue of Afrikaans speaking. Now, that then triggers the question that Honorable Van Wyk is raising in relation to the language issues relating to the Khoi and the San people, particularly there's a Nama issue. Now, the Commission is aware that we have dealt with that. That issue was raised in the Commission before. We just needed to comment on it and let's deal with it so that we can close the issue that the Honorable Member is raising. Let's share that information at this point, and then we'll see if we can close. Van Wyk, is there any other aspect of this that you'd like us to deal with? Honorable Van Wyk, are you still back here, or you've now gone to the main house?
No, Chairperson, I'm still here. I've actually asked him to excuse me in the main house because this is very important. Chairperson, I was actually asking, do the Commission agree with me that to recommend that the Khoi and San languages to be incorporated into the traditional and Khoi and San leadership bill, because that bill doesn't speak to certain aspects. Language is one of them. Would they strongly agree with me and recommend that the bill must include Khoi and San languages, Chairperson? Thank you very much.
So that's the only question you've got, so we can close after that.
Yes, Chairperson. And the other thing is, I just would like to bring it under your attention that that other aspect of Afrikaans hip hop. Do you want me to comment quickly on it? Because I did meet. I did meet.
Sorry,
yes.
You did meet someone in the CRL?
Yeah, no. I did meet with an artist of Afrikaans hip hop, and I did brought it under their attention that I will present to the CRL Commission the issue of Afrikaans hip hop that is not being played on national radio stations. They are not being recognized at the summer awards and so on. So, but that presentation by the artist are not finished yet, because remember, we scheduled that presentation for the 26th of May. And then the CRL Commission appeared today before COCTA.
Okay.
But this meeting also agreed, Chairperson, that the CRL Commission must come again for follow-ups. So that presentation by the artist will be ready the next time they come, Chairperson. So I can share it also with the PC. Thank you, Chair.
Okay, no, then Thank you very much. Look, honorable members, let me just say, let's close this. This issue of hip hop, there's a strong lobby there with the honorable member, and it does need to be brought to the attention of the CRL. So what we'll hopefully do is, as soon as it's ready, we'll share with the CRL Commission. Then you can respond when you come back. But it looks like it's an issue that involves a lot of young people who feel, where do our issues go? And therefore we felt, no, we must bring it to attention. They're not ready with the presentation for now, but what they will do is, as soon as Honorable Van Wyk has got it, he will send it to you so you can then, we do want you to say something about it, address it. What is it? I don't understand hip hop, even West Africans hip hop, but the issue is being tabled for us to say someone feels they are neglected and something needs to be done about it. So we agreed that it must come to you. So it will come, so don't comment on it now. Later, when it's available and ready, then we'll send it back to you. Let's deal with the issue of the language. Again, on this issue of the language, it arises because there's the legislation, the National Traditional Khoi and San Leadership Bill is being tabled. And in the discussion around this matter is a whole lot of matters that relate to the Khoi San community. Now, the Khoi and the San community are raising issues beyond the leadership, traditional leadership structures. They are dealing with issues of language. They are dealing with the issues of mineral rights, land disposition, and all sorts of these issues. Just this one happened to be yours, the issue of language. So the honourable member wants you to comment on it, because in the discussion, there was no reference to the Khoi and the San language issue, and then he feels it needs to be in there, but he wants you to comment on whether, where do you stand on such an issue. So so that you have an understanding as to how does this issue come into it. So please make your comments.
Thank you, Honorable Chair. I'm gonna ask Commissioner Mapanga, who is our liaison with the Khoi San community and is dealing with the Khoi San issues.
Okay. Honorable Chair, Honorable Van Wyk, we must clarify this language issue, Chairperson. The language development of the Khoi and San falls under the Department of Sports, Arts and Culture, particularly Pansal, who must develop the language. Ours is to protect. But to show to the committee that we mean business with the Khoi and San, the resuscitation of the mini heritages of the Khoi and San people is one of our 8 key projects for this 5 years. So we will definitely support, but I can't confirm without saying that this Khoi San leadership bill, I can't remember when the CRL Commission was invited to a discussion. You see, whilst we are protecting languages, the development of the Khoi and San language resonates under Sports, Arts and Culture. Luckily, we have 2 commissioners here who are also board members of Pansal. So from where I'm sitting, to say that the resuscitation of the Khoi and San diminished heritages is one of our projects must put Honorable Van Wyk at ease. That the CRL Commission will definitely support, but there needs to be a coordinated approach when we discuss this bill. And I can't recall that the CRL Commission was ever invited in the discussion of this bill. And it's easy because the Khoi San bill and the CRL are, that commission of the Khoi San leadership and us will resonate under COCTA. So we should have that integrated approach. That is my submission.
I think that's adequate for purposes of what was raised. What I'm going to request is that your name and the name of the 2 commissioners, we can just share so we can then allow private engagement with Honorable Van Wyk. It's obviously a lot of discussion that will help to guide in the process. But from where we sit, I think your explanation has clarified the matter. And so, Honorable Van Wyk, I think we can take it up to this point and we can't take it further, but we will allow the honorable members to share this with you on a private conversation so that you can take the matter forward. You'll bring it back to the committee at the right time when you think you've got a way forward on those issues. The earlier issue you will submit so that we send it to the commission, and then when the commission next comes to appear, they will obviously be ready to deal with your Afrikaans hip hop issue, and that we should give you the space to get the presentation sorted out. Having said so, I now want us to close this meeting. Anyone, any word, last word from your chairperson so we can close?
Thank you, Honorable Chairperson. We would like to thank you for affording us the time. I think it's the first time we engage critically on issues. We appreciate the comments from the members, and we'll continue doing what needs to be done. And we're willing and able to continue engaging with this committee. And as I said on that day, that we'll engage, and then the lawyers must tell us where not to touch. But today, they've cleared us on our presentation. So it's mostly everything that we discussed today, and we'll be willing to engage further. The issue of the budget will be sent through, and all the deadlines will be adhered to.
Thank you. Thank you very much. Therefore, it remains for me on behalf of the Portfolio Committee to thank you, Chairperson, Deputy, CEO, and all the commissioners and the staff for making time to come and share your presentations with us. We will be engaging continuously as we move from here. We hope ultimately we'll get issues resolved. I think from our point of view, we'll wait for some of the additional information, and when we see the need, we will actually invite the committee back for further engagement. With that, I want to say thank you to the members. I must apologize. We should have closed this meeting before 2 o'clock, and so I hope that whips will be very understanding as to why we had to stretch it beyond the time. But nevertheless, for your patience, I want to say thank you. And all the other members on the virtual platform, thank you very much for your participation. And we now, at this point, bring this meeting to the end. The meeting is therefore adjourned. If you go to the extreme on the other side, we have some refreshments. We would like to invite the chairperson, the deputy, the CEO, the commissioners, the staff, everyone to go past that point to have refreshments. And after that, this meeting would have been closed. Thank you very much. Meeting adjourned. Thank you.
Thank you very much, Chairperson and honorable members.
Members, don't forget, Scopa still invited members to join him for the eThekwini meeting tomorrow. I'll send the invitation on the group